Good evening. This is a meeting of the Evanston Plan Commission. My name is Scott Peters, and I'll be chairing the meeting. We do have a quorum. We are expecting an additional member to come, but I thought I'd read our opening statement while we wait for his arrival, and if he doesn't come, we can go ahead with the quorum. The hearing tonight, plan development proposed for 1571 Maple Avenue, is a continuation of a prior hearing which was adjourned, and under Illinois law it doesn't have to be renoticed. We can just continue the hearing at a new time and place. The responsibilities of the Plan Commission include holding hearings and making recommendations to the City Council on land use matters involving planning considerations, including considerations of plan unit developments. Under Illinois law, the city, in considering a plan unit development, has to conduct a hearing, and there are a variety of laws and judicial decisions on what's required for the hearing. In Evanston, the final decision on plan unit developments is made by the City Council. What the Plan Commission is required to do is make a record, meaning what people say at the hearing, make some findings with respect to the standards, and a recommendation to the City Council. Sometimes the City Council will follow our recommendation, and sometimes they do something else, but we will make a recommendation and findings. Our findings and recommendations are supposed to be based on the standards. No single standard is determinative under the Illinois case law, but we must consider all of them, and the council will consider them too, although the council may not make specific findings. We are also governed by the Due Process Clause of the Constitution as it's been interpreted by the courts and the statutes. So we take testimony, and when we're done, we formulate some recommendations and make findings. Our debate and discussion will be in the open meeting right here for everyone to see. Sometimes we all agree, sometimes we don't, and we'll take a vote and see if there's a majority to recommend or for or against a proposal. Since we have to make our findings and decision based on the standards, the evidence we hear should be related to the standards as they apply to the proposal. I urge people in making their testimony and comments to connect their comments to the standards, because other stuff we're not supposed to be using in making decisions. Due process means everyone can address the commission, but there are some reasonable limitations, including time limitations, that are placed on the testimony. I'm requesting that if you are speaking, your statements be relevant particularly to the standards, and copies of the standards are available for you. Where are they? On the podium, maybe other copies too. We'll get some other copies. I'm also going to ask that people don't give redundant testimony. So if, for example, Mary might speak in favor of something and make an argument, and your argument is the same as Mary's, instead of having everyone make the same argument, you can say, my argument is the same as Mary's. I think she did a good job and was correct. And then we'll know your position, and we won't be here till 5 in the morning. Here is the order of presentations. You've already discovered we start with an introduction by the chair, explaining something about the commission and how we proceed. Following that, an oath is administered, and this is a continued hearing, so people who took the oath at the last meeting are still under oath to tell the truth. And let me take this opportunity to ask anyone who plans to speak to raise their right hand and take the oath now before I forget to do this. Do you swear or affirm that during this hearing you will tell the truth? Great. Following the introduction by the chair, we would have a staff summary of the matter, and then the petitioner presents testimony. At the end of the petitioner's testimony, anyone within 1,000 feet has a right to ask for continuance. And at the last meeting, we heard from the petitioner and someone asked for continuance, and so here we are tonight. Today we'll begin with a statement from the Secretary to the Commission identifying what's been placed in the record, and I think he'll say it's the same as what's in the packet. We have a requirement that things be submitted in advance, and the chair has discretion to waive that requirement. I will do so, but only if there is someone here to testify to things that weren't submitted on time. After the secretary or their designee has finished, then we take public testimony or comment. When you testify, please come forward to the podium. It's helpful to us if you identify yourself and give your name and address, but under a recent decision by the PAC, if you don't want to identify yourself, you can still testify. There are some rights for people within 1,000 feet of the property. So if you don't identify yourself and you hold your address silent, we won't know that you're within 1,000 feet of the property. But you can talk without identifying yourself. So we begin with public testimony, first taking comments from organizations and attorneys representing organizations, a presentation of witnesses, opinions from groups, and after each expert witness testifies, the commission can ask questions and other people can ask questions of the witness. Commission members and others can cross-examine the witnesses and ask questions to clarify what was said. When the organizations and groups are finished, then we'll hear from the individuals. And after each individual speaks, they too can be asked questions. Our rules provide a time limit for statements from organizations regarding the proposal under consideration of 10 minutes and other testimony of 2 minutes, but given the complexity of this case, we won't be strictly enforcing those time limits until people get redundant, and then we'll say, stop, please. Or if they go off and talk about things that we can't consider because they're not related to the standards, my job is to say, can you tell me how it relates to the standards? It's really helpful, and under the rules required, that cross-examination of a witness relate to what they said and not to other things. And that the testimony relates to the standards. After hearing all the statements and the evidence from people who might be opposed to the proposal or people who might support the proposal other than the petitioner, there's a chance for questions, and We then allow the petitioner a reasonable time to respond to the public comments and public testimony. Finally, after hearing their response, commission members ask questions of the staff and can ask questions, and we hope such questions won't be argumentative. When that's all finished, we'll take a short break. There'll probably be breaks before that. We'll take a short break, and each side can submit closing arguments, usually about 5 minutes each. After the closing arguments, testimony is closed, and then we don't take any further comments from the public, though sometimes the commissioners will have questions of someone who's spoken is still here, and that's allowed. The commission will hear from staff at the end when the testimony is closed, and then we talk about it, sometimes for a long time and sometimes not so long, and eventually someone will make a motion and we see what commissioners have decided. The commission then takes action, making findings on the standards and a recommendation to City Council. We take a long breath and go to bed. The rules provide that the Plan Commission has to make its recommendation within 120 days of the first presentation of the applicant. So if necessary, we'll hold additional meetings and try and get the matter finished within 120 days. If the matter is not concluded tonight, it'll be continued to a date certain, just as it was after the first hearing. And tonight we would announce the time and place of the next meeting. So at this point, having, I hope, explained the process, I'll see if staff has anything to say, and then we'll begin hearing from those members of the public, others other than the petitioner who's already spoken.
Thank you, Mr. Chairman. As you requested, I'll just point out the items that have been submitted to staff since the last hearing. Per the Plan Commission's request, the applicant has submitted a few study diagrams and the market impact analysis. They have also submitted facade area volume study, exhibit, shadow study diagrams, and a memorandum regarding the parking needs for the proposed development from the Center for Neighborhood Technology. They've also submitted an exhibit showing the on-street parking restrictions in the area around the proposed site. We've also received materials from the Winthrop Club Condominium Association. They've also submitted a market impact analysis and additional information regarding the standards and how the project is related to those standards. All those items have been submitted and they are part of the packet that was posted online. That's it.
Is there anyone here representing an organization, group, an attorney who has witnesses who wishes to address the commission?
Yes, Your Honor. Mr. Chairman.
It's the first time someone's thought I'm honorable.
I just got out of court at 4:30, so I was going to Mr. Chairman. Members of the commission, my name is Tom Ramsdell. I'm an attorney representing Winthrop Club 1 Evanston. My offices are at 200 South Michigan Avenue in Chicago. I'm a lifelong resident of the North Shore and spent the happiest of my few married years living right here in Evanston. I request a point of order before I go ahead and present our case, and I will do so as concisely as possible. At the conclusion of the last hearing, we agreed to continue our cross-examination of the applicant's experts. I do not intend to belabor that right, but I do have a few handful of questions for 2 or 3 of the experts.
That's certainly
would you prefer that I do
consistent with our rules.
Shall I do that now then before I begin our case? It's technically, I guess.
That would be fine.
Okay. So the first person I'm going to ask from the applicant's side, do we have a second mic? I think we did the last time. We had one we could stand over here with. What I propose to do is allow the witness to stand here at the podium, and I'll sit over here. The first expert from the applicant's side, shall we say, is Mr. Marous. Is he here? Good evening. I'm sorry.
Michael Marous, I was here at the last meeting.
Mr. Marous, again, my name is Tom Ramsdell, and I just have a few questions for you. At the last meeting and in connection with your report, I seem to have reached the conclusion that you opined that there was no or minimal impact on the Winthrop Club and the surrounding neighborhood from the proposed development. Is that correct?
Yes.
Okay. And in reaching that conclusion, did you consider the public benefits standards relating to the applicant and its request?
Yes.
And did you consider the housing goals provision with respect to public benefits furthering Evanston's housing goals?
In general, yes.
Okay, and what housing goals did you consider in general in reaching your conclusions?
To provide more modern development in downtown Evanston, to provide rental housing in downtown Evanston, to basically further, I think it's called TOD, development in downtown Evanston, to name a few.
Did you consider all the city's housing goals relating to affordable housing?
I looked at them, but that was not part of my analysis in this situation.
In arriving at your opinion, did you consider the standards set forth at section 6-3-5-10 of the Evanston zoning ordinance, which I'm not going to hide from you, that's the special use provisions?
Yes.
And is it your opinion that the applicant's submissions, that its proposal meets the standards set forth in there?
In my opinion, yes.
Okay. If your opinion was that the proposed apartment building would have no or minimal impact on the Winthrop Club and the surrounding area, let me ask you, if that structure was simply diminished by 25% in size, would that at all impact your opinion as previously stated?
I would have to study the plan and look at the impact and to study if it was financially feasible and how it was laid out. Quite frankly, if it was pushed further to the south, as it could be, now it's about 50 feet, the main structure itself in the upper levels, from one Evanston, that probably would be a negative in my opinion.
So if it was smaller, that would be a negative. What do you mean by negative?
No, if it was made smaller, but as part of the design pushed further to the south, as it could be, if it was smaller, it would actually be more proximate to the north-facing units, which I think tiers 6 through 11 in one Evanston Place.
I want to ask you just a question or two about your match pair analysis. I understand from reading your report, and I admit I'm not an expert, I'm just a lawyer, that I don't understand all the language, but I understand you had basically one data point out of reviewing the sales of 485 units. Is that correct?
No, we looked at the market but thought the Optima development was the best comparison when making the analysis.
But in part of your report, you indicate that there were 485 units that you reviewed, that were sold within the time period you chose to look at, correct?
That is correct.
And out of that, there was one, if I'm not mistaken, please correct me, there was one that you chose to focus on for your analysis.
That I thought was most appropriate, correct.
So there were, of the 485, you were only able to find one unit that actually, that you thought had data supporting the conclusions that you reached. Is that right?
I looked at the market, and that's what I thought was the best indication. That's correct.
And just finally here, on page 17 and 18 of your report, you call it the matched pair, and you are looking, or you review and analyze units 710, 1002, and 802. of that Optima building, correct?
Correct.
And you have, in your analysis here, if I read it correctly, the unit sizes are all roughly the same at about 1,100 square feet, 1,010, 1,000, is that
They're in the
correct?
same range, yes.
And then there were other variables that you discussed, including position, location within the building, height, what floor you're on, parking, whether there's a parking spot. Is that correct? There are other variables that went into your analysis, right?
Corner, location, height, yes.
Okay. Let me ask you, if the square footage of one of the units was significantly different than the other, would that be a variable that might change or might impact your analysis?
It might.
I have no further questions.
Thank you.
Thank you. The next gentleman I'd like to call would be the expert from KLOA, whose name, unfortunately, I have forgotten. And I do apologize for that.
no
I saw
problem.
the report. I didn't know which one you were. If you could please introduce yourself.
Michael Worthman with KLOA.
Just have a couple of questions on your study. How many spaces under the Evanston zoning ordinance would be required for the proposed development?
According to the staff report, 142.
And how many are on site?
13.
So, I'm not a mathematician, but if I subtract 13 from 142, we have 129. We've got to comply with the ordinance, we'd have to have 129 spaces.
To comply with the ordinance, you would need 129. However, they are making arrangements to provide 101 at the parking garage.
You read my mind. So there's leasing 101 of the 129. So under the Evanston zoning ordinance, which is certainly some of the standards the Plan Commission's looking at, we still have a deficit of 28 spaces. Is that correct?
I will trust your math. Correct.
All right. The 13 on site, how many of them are public spaces?
There'll be 2 for car sharing, and the rest will be public.
I think that's 11 then?
Yes.
Yeah. And how many spaces are for persons with disabilities or basically what we think of as handicap parking?
I believe 1.
Are you familiar with Illinois state law on ADA requirements for handicap parking for residential developments?
To an extent, yes.
Do you know how many the law requires for development with between 101, I believe, and 150 units?
I'm not sure offhand.
Do you know whether or not this particular development complies with that law?
It's complying with the number of spaces that it's providing on site.
And how about for handicapped persons?
My understanding it is.
Okay. And I ask just one final question. How would you propose that the elderly and handicapped and other persons with disabilities would be able to walk nearly a quarter mile in our inclement weather to get to their leased parking space at the Maple Street garage?
Can you repeat the question?
Yeah, how do you propose elderly and handicapped people would be able to walk that roughly quarter of a mile in inclement weather in order to get to their vehicles if they're leasing an off-site parking as proposed?
I'm assuming they probably will not choose to rent from this facility, given if they are parking in the parking garage. There's other choices in Evanston where they can rent.
But this development certainly would then deter the elderly and handicapped from being able to live there, wouldn't it?
No, not necessarily. That's a choice they would have to make.
I have no further questions.
Thank you.
And one final on the cross. Steve Lennett, please. Hello, Mr. Lennett. We've known each other. Would you please introduce yourself?
Yes, for the record, my name is Steve Lennett, L-E-N-E-T. I'm a land planning and zoning consultant.
Mr. Lennett, when we heard you testify in November, I believe one of the points that you made is that you were, in fact, the planner for the One Evanston building, correct?
That's my recollection, yes.
And when the One Evanston building was going through the application process and ultimately being approved, the downtown plan adopted by City Council in 2009 was not in effect, correct?
That's correct.
And you agree that the downtown plan, in fact, looks at the subject property, and by that I mean the applicant's proposed property, differently in terms of land use intensity than the standards that were in effect back in 2005, roughly, when One Evanston was being considered.
Well, The 2009 plan is an addendum that builds on the basic plan that was adopted prior by the city council.
But it does look at the property differently in terms of what was looked at with 1 Evanston.
Yes, it goes into more detail.
Did you ever advise your client at Winthrop, 1 Evanston, that buildings might be built directly to the north or to the south of it within that same block when you were representing it as a planner?
I was never asked that question.
Did you ever advise them of it?
I don't think they needed to be advised. It's clear that given what has happened in downtown Evanston over the past 20 years, that vacant property is going to be developed, and generally it's going to be developed in a manner that's consistent with the comprehensive plans that have been adopted by the city council.
And is this building being developed consistent with the downtown Evanston plan, which is part now or adopted as part or as an addendum to the comprehensive plan?
Yes, as the staff report points out, it is in compliance with in many respects with the recommendations of the downtown plan.
Would you agree that the 2009 City Council action in adopting the downtown plan basically looked at the intensity of use for this property and others in the downtown area and decided that in terms of land use intensity that it should be lower than 1 Evanston is?
It looked at a number of factors, and the recommendation is for less intensive use. However, it also is developed under the plan development standards under the zoning ordinance. The zoning ordinance, as you're well aware, is the document that actually controls development. The comprehensive plans are recommendations and don't carry the same weight as the zoning ordinance. So the fact that the development, in my opinion, is consistent with the plan development standards contained in the zoning ordinance is the controlling factor.
And similar to the question I asked of Mr. Maroos, in reaching your opinions, did you evaluate section 6-3-6-3 again, the plan development public benefit standards in the Evanston zoning ordinance?
Yes, I did.
And arriving at your opinions, did you consider the city of Evanston's housing goals?
I did.
And what are they, to your understanding?
Well, one of the primary goals is to provide affordable housing in the city of Evanston.
And is it your testimony and opinion that somehow this structure will provide affordable housing in the city of Evanston?
I think the fact that it provides rental housing versus for sale housing, which has been more the norm in the downtown, is significant, that it will be primarily market rate housing. But the fact that these are the size of these units, the square foot price of the units, I think are consistent with the goals and policies adopted by the city council.
Okay, I have no further questions. Thank you, Mr. Leonard.
Thank you.
Mr. Chairman, that concludes the cross-examination portion.
Thank you.
We'd now like to move on to our primary, what I'll call the primary case, and our objections to the applicant's proposed development. With us tonight are 3 experts in the field in terms of who will be testifying as part of the organization, as well as its president, Howard Ellman. Our first expert will be Alan Krakauer. Alan Krakauer is the principal of Krakauer and Associates, land use consulting and development and zoning firm for over 40 years. And I would like at this time, testifying as an architect and providing some of the renderings we'll see and some of the impact studies we'll see will be Bill Kokalius. Mr. Kokalius is principal of Axios Architects, located downtown, and has been involved in dozens, if not hundreds, of residential and commercial developments in the city and in its suburbs. Mr. John Satter is an MAI, an appraiser, will discuss briefly Mr. Maroos's report and provide his own opinions with respect to market impact as requested by this body. And finally, Howard Ellman, the president, will testify as to impact in some general statements on behalf of his constituents or the Winthrop Club, and address specifically some of his concerns with the compatibility with the downtown plan. I think at the end of our presentation we will show that with respect to both the downtown plan, special use requirements, and the requirements for plan development, standards this body will consider, and as the chairman eloquently stated, will consider after this hearing, that in fact the applicant does not meet the standards set forth in any of those 3 critical documents. So without further ado, Mr. Krakauer.
Can you be sure that council has one?
Samir, does this just hit the top button to change it? Are you going to do it? Okay, thank you. I'll let you know when I want it. Okay.
All right. Mr. Krakauer, as you know, my name is Tom Ramsdell. I represent Winthrop Club 1 Evanston. Thank you for joining us this evening. Would you please briefly provide the commission with your credentials?
Yes, my name's Alan Krakauer. I'm the president of Krakauer and Associates, urban planners, real estate consultants. It's a firm I founded approximately 40 years ago, in Evanston, by the way, in a building that no longer exists. I have planned somewhere in excess of about 300,000 acres of land of all different types. I presented my credentials as an expert in planning and zoning, and they have been accepted in the Cook County court system, and as far as that goes, in every trial court of northeastern Illinois. Recently, on a more recent basis, I did actually represent the city of Evanston on some zoning litigation a little over 24 months ago. And the city did, and I testified on land use and zoning and planning. So at that point, I became very familiar with the zoning procedures of the city of Evanston, and the city did, in that instance, prevail.
What was the nature of your assignment, if any, with respect to this application, and what was your initial observation after reviewing the proposed development at 1571 Maple?
I was asked by the client to review the proposed development in context of the very standards that Chairman Peters discussed. The standards for special use, the standards for planned unit development, the so-called public benefits that would originate, and then to look at the overall purpose of a planned development. And I did that, and after my general review of it, and I think you're going to hear from me tonight, with all due respect, some commentary that will be different than the staff report. Although I have certainly a great deal of respect for other planners, but my opinions are somewhat different, and I will explain to you why as I go through each of these individual standards at some point. But my initial observation was that this was an excessively dense development, that it was not compliant with the principles of a planned unit development. In other words, in the city of Evanston, in order to have a PUD, special use approved, you must have public benefits. You must get over that hurdle. And if you're going to ask for additional density or less parking or any other deviations from the standard D3 underlying zoning, you have to give something back to the community. In this case, when I looked at the items that were submitted, I didn't find anything coming back in return, but what I did find was an intensely dense development. Specifically, the underlying zoning permits about 73 dwelling units, according to the staff report. This applicant has asked for 101 dwelling units. That's an increase of over 30%. So in any zoning case, when we get an increase of over 30% and we're reaching up to 100 units, it's a very, very significant increase. Parking was the same situation. Here, as their own parking expert indicated from KLA, a very good qualified expert, they require 142 parking spaces to accommodate the 101 units. Parking spaces and requirements are in a zoning ordinance for a purpose. In fact, the very standards you have originated right here in Evanston, I think from Barton Ashman 30, 40 years ago, and you use some of those same standards today. But instead of 142, they only provided about 101 and 13 on site. So they have a deficiency of about 28 spaces or 25%, less than what they really need. The problem with that is there's almost no parking on site. You have 101 units, and at least 101 people living in a building. You have approximately 13 spaces on site, and for some reason, which I cannot understand, about 11 of those are designated as public. So during the day, at some hours during the day, The public will use the spaces. The residents don't get to use those because the public are using those. They have one accessible space under the ADA. And you heard something that I thought tonight was incorrect. When the gentleman was asked the question, do you complied with the ADA requirements? I believe they have not. Because he said we have enough based on the amount of on-site parking. In other words, instead of basing it on the 101 units you have in your building, you base it on the 13 spaces you have on site. So if people are physically challenged, and certainly out of 100 and some people, they may be that way, or if people are seniors and have some handicap problems, some physical problems, there really isn't any availability of parking that's accessible for people of that character. And I think that was, I would disagree with that statement. The other part that we have to deal with here is...
May I interrupt you just one moment, and if I'm jumping ahead, please let me know. Do you know what the requirement is for the 101-unit building for handicap parking under Illinois law?
I've estimated, looking at the ADA state requirements, for about 100 and some units, you're in the range of about 5 spaces. And I think the architect who does that kind of work would have to look at that more carefully. But the last problem that I noticed in terms of over-intensification was the parking garage. Now, we're told by the staff the parking garage is about 1,000 feet away as a bird flies, or crow flies. But people aren't crows. We walk. And when we walk to get from point A to point B, it's further than a straight line. So it's really about 1,500 feet. And section 16.2.1 of your ordinance says it cannot be more than 1,000, but it is more than 1,000. So I don't know, in terms of ADA, how seniors, if there are any in this building, I don't know how people who are physically challenged are going to walk, especially in this kind of inclement weather, to get to that parking garage and back. It's just not going to work. So we've rarely seen buildings that are geared for only people 30 years of age and younger. This will not work, and this will exclude a significant portion of the city's need for housing. Furthermore, if you're going to, in the zoning ordinance of Evanston, if you're going to have off-site parking, it must be on the same zoning district that you are on with your project. In other words, if this project is D3, the parking garage has to be on D3. It's not. It's on a research park. And if you're going to have a different zoning, such as research park, the ordinance says it has to be more restrictive than the D3. It is not. It's less restrictive. So there's another technical problem as to why this garage, in addition to the distance, which you can argue about for a long time, there's the issue that it does not comply in context of the actual zoning requirements that are organic to the ordinance. Finally, in terms of that, it's my opinion this is not a planned unit development. That planned unit developments in Evanston and other places, based on experienced planners such as myself, have been abused and misused and have become a vehicle for excessive density. Now, if you turn to the first slide for me, now that's my opinion, but it's not merely my opinion. And I'm showing you a slide I know you can't read. Mr. Chairman, I knew you were going to ask, but then, and I can't read it either, but I have a copy in front of me.
I think they do too.
And so there was a reference to the 2009 just a moment, please. There was a reference to the 2009 comprehensive plan. And so, although I've told you I don't think this is a proper use of the PUD, I'm going to read this to you so it goes into the record, because whoever wrote this part of the comprehensive plan.
There is no 2009 comprehensive plan.
It's a downtown plan.
There is a downtown
plan.
Which was adopted by
the city council.
Not by ordinance, but by resolution.
By resolution by the city council. And it still becomes, I believe, Mr. Chairman, at least in my opinion, an official plan of the city. So says the city attorney in a letter I just wrote. I just read.
The city attorney said the downtown plan is part of the comprehensive plan?
He referenced to it. He got very close to pulling them together.
We better have that in evidence.
Yeah, so there's a letter that I read, and you may desire to read it also. But regardless, whoever wrote this document on behalf of the city and having the city council approve it, went on to say that the allowance and exception process that is commonly used in providing planned development projects is not working. Such allowances and exceptions have lowered people's expectations in the planned development process. Residents of Evanston see downtown development review as an ad hoc case-by-case assessment where decisions are made by the city council without sufficient consideration of the principles of comprehensive planning and the tenets of good urban form. Current development allowances are permitted when the Plan Commission and City Council find a project incorporates public benefits as described in 6363, and that's true. However, the public benefits listed there are vague and general, and recent PUDs, pleadings, the purported public benefits developers offered in exchange for allowances include the payment of taxes, the redevelopment of vacant land, and the creation of jobs. These benefits are not unique or specific to a development project and do not relate to the immediate impacts on the neighborhood. So whoever wrote that, I concur with what they say, and I agree with whatever that plan is and however it has been adopted. One last thing on transportation-oriented development. You heard that. The planned development is law. Transit-oriented development is not law. It's a planner's concept. And transit-oriented development does not mean that you don't put parking in a building. There is no such concept. And there was a letter from the petitioner that came in as an addendum that referenced to certain TOD developments. One was in Wicker Park, Chicago. Evanston is not Chicago. One was in Minneapolis. Evanston is not Minneapolis. And one, I believe, if I recall correctly, was Portland, Oregon. And Evanston isn't Portland, Oregon. So there's I think what I heard in terms of the testimony the first evening regarding transit-oriented development, from my opinion, would be incorrect.
At the Commission's request, Mr. Quacker, I need to just ask you a very quick question. You referenced a letter or a memo from the city attorney to the Commission. Do you recall that?
Yes, I do.
Was that be a memo dated December 9th, 2014?
Yes.
And were you just referring to the section called applicability of the 2009 downtown Evanston plan? Is that what you're talking about?
That's correct.
Okay. Next question. Continuing on with the subject of public benefits you mentioned, did you evaluate section 6-3-6-3?
I did.
Planning development public benefits?
That's correct. And briefly, my findings are pretty brief, actually. There are a number of factors that the Commission is obligated, and theoretically the City Council is obligated to consider before a planned development can be granted. In other words, the developer has to give something back of substance, not a sidewalk and not a tree and not 3 shrubs. So if we go through these standards, and I'll do it very quickly, preserve and enhance desirable site characteristics in open space. The answer is no, because I don't know if there are any desirable site characteristics, and there was no open space of any significance in this development. Sometimes we do see significant open space. Here we don't. Maintain a pattern of development which preserves natural vegetation, topo, and geologic conditions. Those factors really don't exist. And the reason you're seeing these, they're not old-fashioned, because PUDs were geared to larger properties, not the small properties we're talking about tonight. Preserve and enhance historic and natural resources? No, it doesn't do that, because there aren't any. Create pleasing environment or other special development features through design, landscape, or architecture? I didn't see anything unusual that would be of any benefit to the public. Provide a variety of housing types in accordance with city goals. This is perhaps one of the most important ones, because the question has to be asked, what are the city goals? The city of Evanston, and you can switch to the next slide, the city of Evanston receives annually about $2 million from the United States government through the Department of Housing and Urban Development. I'm familiar with the program because when I was a young man, I was appointed as a special assistant to that agency. And every year when they obtain their $2 million, they submit an application. The one you're looking at is from 2010 to 2014. A new one is in the process of being prepared. And in this document, in return for the $2 million they receive for various projects, they advise the United States government to make commitments as to the type of housing that is needed in the city of Evanston.
And who's the they?
The city of Evanston is they. And this document describes a need for senior housing, describes a need for housing that is for people who are physically challenged. And if you read on the cover, I put the quotation on the cover. And it says, affordable housing continues to be the city's highest priority. Affordable housing. And you heard tonight that one of the experts on behalf of the applicant said this is affordable housing. Well, let me just tell you what the rents are. The smallest one starts out at $1,600. Then they go to $2,000, $2,600, $3,400, with an average of about $2,200, $2,200. That is not affordable housing. That's not senior housing. That's not handicapped housing. In fact, this project, which is a pretty big project for this city, 100 units, has absolutely no regard or consistency with the very plan the city has submitted to the United States in return for the $2 million they've been getting for a couple of years. And there's a few other items I just want to go through. The last ones, I'm going back one slide, and I'll touch upon those. Eliminates blighted structures or incompatible uses. I don't think there's any significant blight. Enhances the local economy and strengthens the tax base. I think that's sort of yes or no, because any building you would build will have real estate tax revenue that generates to the city and to other local taxing jurisdictions. They have a very little bit of commercial in here, about 3,500 square feet, pretty small. So there might be some sales tax, but any building does that. So there is no public benefit to the community or the area from this particular development. Next one, efficiently uses land resulting in more economic networks of utilities, streets, schools, public. That doesn't happen. That's geared to a larger development where you have a master plan, you have new roads, new streets, new schools, new infrastructure. That hasn't occurred either. Incorporates generally recognized sustainable design practices. And I think it is going to be a lead building, so it does do that. But overall, I would say that in terms of Section 36363, Plan Development Public Benefits, the project clearly does not comply.
Mr. Krakauer, did you consider the public benefits in the petitioner's application, and what are your opinions?
I looked at them, and they seem to have been developed, rather ironically, in conjunction with the staff, because the staff report says these are things we're going to ask for. I'll just touch on a few of them. Installation of a parking lot. That's not a public benefit. Installation of one free electric charging station with the on-site public parking. It's nothing of any significance. Improvements and expansion of a public sidewalk. 2 car share parking spaces. Reduced car share membership fees for building residents. And there are some others that may be more applicable. But overall, these things that are being suggested as public benefits, both by the applicant and by the staff, in my opinion, are not public benefits and do not aid the community or the neighborhood of which they're a part. They aid the developer.
So is a public benefit something above and beyond which is basically required so as to justify, like, so to speak, to trade in exchange for the allowances that come under the special use?
Yes. So in essence, in order to get to the point where you, in the zoning ordinance, in order to get to the point where you even look at the plan development standards, you have to first overcome the hurdle of 6-3-6-3, and that hasn't happened. So you can't even get to the plan development part of it, but we'll do it anyway.
As part of your analysis, did you consider section 6-3-5-10, excuse me, standards for special use?
I did. And they're on the screen up there. Again, I'm going to go through these quickly because I'm almost completed with my testimony. And it says, is it one of the special uses listed in the zoning ordinance? And the answer is it can be. It's a plan development, and plan developments are listed. It doesn't mean much, but they're listed. Is it in keeping with the purpose and policies of the adopted comprehensive plan, the zoning ordinance as amended? In my opinion, no. And it is not in keeping with the downtown plan in any respect, in terms of land use density in particular, even if you just look at the overall intent of the plan. Will it cause a negative cumulative effect when considered in conjunction with the cumulative effect of various special uses of all types on the immediate neighborhood? I think the information the Plan Commission received on that from the staff was incorrect. They said there was no. I believe there is a negative cumulative effect. And what that really means is that if you have one Evanston, you have this building which is being developed on the north. And once that goes, then there's the cumulative effect of another building being built on the south of one Evanston. So there is clearly a negative cumulative effect, or at least a cumulative effect. One leads to another, to another, to another, and at some point there's no end to it because one says, I did that, they did that, so why can't I do that, and then why can't I do that? Does it interfere or diminish the value of property in the neighborhood? There's an appraiser tonight that will deal with that. That's not my level of expertise. Can it be served by public facilities? Yes, any development can be. Does it cause undue traffic congestion? The answer is yes. And how can it cause undue traffic congestion if there's no parking? And I'll tell you, if you look at the last addendum you got from KLOA, the traffic consultant, and he did this in response to a question, it might have come from Mr. Ford, I can't remember exactly, or the chairman, how much parking is available in the neighborhood that possibly these people would pay for? And that study that they did is very interesting because it drew about a quarter-mile circle. It went to the very edge of the proposed parking garage that exists where these people are supposed to park, and it drew a great big circle. And if you look inside that circle, you're going to see both free parking and paid parking closer to the building than the parking garage. So what do you think is going to happen? You don't have to be a traffic expert to figure that out. Does it preserve significant natural environmental features? No, there aren't any. And lastly, does it comply with all applicable regulations of the district in which it is located? No. And other applicable ordinances? No, except to the extent such regulations have been modified through the PUD process. So if you let them modify it, you can do what you want to do. But certainly it is non-compliant.
And finally, Mr. Krakauer, did you consider the conditions pertaining to planned developments?
I did. And again, there's so many of them, and you can't read them. And I'm just going to cover three things, because I think that's about all it really needs to be said. In section 611.110, which is the plan development section that the chairman asked us to comment on, there's one sentence here that's very critical. It says, in addition to the general requirements for plan development set forth in section 636, that's all the things I've been talking about. In addition to those, the Commission shall not recommend approval of, nor shall the council adopt the plan development in the downtown unless they shall determine based on written findings of fact the plan development adheres to the following standards. And I'll just take a look at a couple of the following standards. Each plan development shall be compatible with surrounding development and not be of such a nature in height, bulk, or scale as to influence contrary to exercise any influence contrary to the purpose and the intent of the zoning ordinance. Section 612, and if you look at the very beginning of the zoning ordinance, you're going to see something on valuation. It's my opinion that this development has an adverse impact on one Evanston. Every development has an impact. Single-family homes impact one another, not much. But when you have a development this big, there's an impact. And then the question to be asked, is it an adverse impact? The answer is yes, and I think you'll see that as we go through our testimony tonight. Each plan development shall enhance the identity and character of the downtown by preserving, where possible, character-giving buildings. Not sure what that means, character-giving buildings, but the only character-giving building is one Evanston. And certainly this development does not enhance it, it takes away from it. Lastly, and then I'm done, each plan development shall be compatible with and implement the adopted comprehensive plan as amended the plan for downtown Evanston, Evanston, it has to be compatible and implement that plan. And then it gets into land use intensity, right thing. Clearly, and again, one need not be an expert in anything. You have to read English, but anybody who can read that downtown plan knows that what it sets forth is a much lower intensity type of land use than, for example, what was permitted some years earlier in 1 Evanston.
Thank you very much.
Thank you.
The petitioner's attorney may cross-examine.
Done this before with Mr. Krakauer. Mr. Krakauer, your degree is not in urban plan, it's in landscape architecture, correct?
Master's degree in planning and landscape
Oh,
architecture.
you are?
Yes.
It is in planning. All right, we'll walk away from that one. Can you read this for me? I'm showing the witness the December 9th memo, a specific paragraph in the memo. Please read that paragraph. Out loud.
I'm sorry, which one?
Please read. Alan, please don't do this to me. Read the paragraph that starts while the downtown plan. Read it out loud, please.
I'm not doing anything to you. While the downtown plan sets development guidelines for downtown Evanston, it must be noted the downtown plan is just that and no more, a guide for land use regulations in the downtown area. Ultimately, the current zoning ordinance, in conjunction with the comprehensive plan, is controlling in terms of land use regulations and in circumstances of conflict between the downtown plan and the comprehensive plan.
So irregardless of your testimony, A, the downtown plan is not part of the comprehensive plan. Yes? That's what that says.
No, my testimony was a little bit different.
No, it wasn't.
I said that, well, if you allow me to answer, I will. I said the attorney wrote a letter and got very close to implying that the downtown plan was that.
Did that imply that it was part of it, or did it just say it's not part of
Let me
it?
just.
Did it say it was not part of it?
That did say.
Did it say it was not part of it?
There's no need to be rude. The answer is.
Yes, there is.
Well, I don't think that's.
Mr. Krakauer, if you're not going to answer the question and only answer it the way you want to, we can keep on doing this. But go ahead. I will shut up.
We will get a copy of the letter and the commission can read it.
All right, I'll walk away from that
It's not
question.
necessary to make the argument.
I'll walk
to
away from
cross.
that. Mr. Krakauer, you testified as to accessible parking. You estimated how many spaces are needed. It's true, though, that the Illinois, the Act, the Accessibility Act, requires a certain percentage of those parking spaces. Not your opinion whether they're needed or not, but it's true that the Act only requires a percentage of spaces that are provided on site. Did you review the Act?
Yes, and that's incorrect.
No, I'll show you the Act.
But you can show whatever you want. But what I'm saying to you.
It either says what it says or it doesn't.
Well, if you want me to answer, I will. If you want to argue with me, I won't. I'm not here to debate with you. What it says is that, and it assumes that adequate parking is provided on site in context of a municipal ordinance. It does not assume parking is taken off-site, moved somewhere else, and that underhandedly, if you will, you count only the 11 or 13 spaces on site. It's a very backdoor and inappropriate way, and inappropriate for people who suffer from physical handicaps. And,
That is not what the Act states.
well, I understand what the Act
No,
states.
but no, wait. You see, now you did it again. I asked you what the Act stated.
May I ask
You
a
now
point of
gave
order
your
here, Mr.
opinion.
Chairman? First of all, counsel is badgering and arguing with a witness.
Yes.
And secondly, I'd like to add that during the applicant's presentation, we waited until the end to conduct our cross-examination, which was tonight. So I'm going to move that we terminate this cross-examination, and Mr. Citron can do what he wants at the next hearing once, or later tonight, once our evidence is in.
I'd like to proceed with the cross-examination after the witnesses. The question.
I have nothing further,
the
Mr.
question that
Krakauer.
was
I have nothing
asked-
further. I have nothing further, Mr. Krakauer.
The question that was asked was not about the testimony was that there wasn't compliance with the Act. That was the subject of the question. Eventually, we'll get a copy of the Act, and the commission will look at it, and we don't have to do that through cross-examination.
Just a quick question, and we can move on past Mr. Krakauer. In connection with the document that Mr. Citron just asked you about, did you read the area written by the city, the part written by the city council that says, if a particular ordinance provision is challenged in court, comprehensive plans assist the city in articulating the basis for its legislative decisions. Area planning documents, such as the 2009 Downtown Evanston Plan, adopted on February 9, 2009, serve to supplement the comprehensive plan, providing more tailored guidelines and vision for development of a certain area. Did you read that part?
I read that, and more specifically, to add an addendum on to a letter I didn't write, when a plan is mentioned in a zoning ordinance, it takes on more significance than if it is not mentioned. So although that letter, I believe, is correct, and I've testified this in courts for years, and have never been corrected, when you mention the downtown plan as part of a zoning ordinance,
And
it
where
has greater
would that be?
significance.
No ordinances were adopted implementing the downtown plan.
Your Honor, if I might, I believe what you're referring to is section 6-11-1- Plan 10 under plan developments that says each plan development shall be compatible with and implemented the adopted comprehensive general plan as amended, the plan for downtown Evanston. I believe that's what he's saying is incorporated directly into the Evanston ordinance.
And where do you see that in the ordinance?
611-110, plan development, where it says specifically, item 3, each plan development shall be compatible with and implement the comprehensive plan as amended, the downtown Evanston plan. I testified to that.
Did you locate any document that incorporates the downtown plan into the comprehensive plan?
That's not what this said. That's not what I said. What I said is that when a plan is mentioned and specified within the text of a zoning ordinance,
And where would that be?
that's in section specifically 611-110, plan development.
I'm looking at it on my computer. I don't see a reference to the downtown plan.
If I may step up,
Yeah.
what's right here? Number 3.
Where is that? Is this the ordinance? Okay. I stand corrected.
Okay. Is there anything further of me?
Let me ask the commission if they have questions, and then the public if they have questions.
I do have a question, Mr. Chairman.
Oh, go ahead.
But I'd like to know the status of the downtown plan.
When did that happen?
There's a question in my mind currently whether the downtown plan is merely advisory or whether or not it is incorporated in some form of reference to the zoning ordinances.
It's a legal question of some difficulty.
I mean, I thought it was advisory last couple of weeks ago. I was of the opinion that it was advisory. 2 weeks before that, I thought it was adopted by the city council and incorporated into the zoning ordinance. I was wrong about that.
It is a comprehensive plan. I'm sorry, it is a downtown plan. And the status of it will be the subject of argument, probably beyond tonight. I did look at the cases and concluded it's a difficult question.
Chairman Peters, if I may. This is Mario Tretto, the city attorney. I'd like to make a couple of points of clarification with respect to the letter that, the memorandum of law that I produced. Just a few points of clarification. The current zoning ordinance is the applicable and governing code. The said code must be looked at in light of the comprehensive plan, which is the official statement and policy of the city of Evanston regarding physical development of the downtown community. Additionally, the downtown plan serves to supplement the comprehensive plan, as we've discussed earlier. The downtown Evanston plan update was formally adopted by City Council on February 9, 2009. The downtown plan had numerous recommendations and serves as the city's vision of the downtown area. The downtown plan included a recommendation to adopt a form-based code in which a conceptual strategy, a draft, if you will, was included at the end of the downtown plan. A revised version of this form-based code was recommended for approval by the Plan Commission on February 9, 2011. This would serve as some sort of implementation of this downtown plan that has various recommendations, suggestions. If you look at the document itself, there's a lot of should versus shall. However, the City Council did not adopt the form-based code, did not adopt the implementation portion of the downtown plan. Therefore, the governing zoning law needs to be applied this evening, and that's what is the governing law as we move forward today. So hopefully that provides some guidance or some light into the question that Commissioner Upbeck had.
Thank you for.
So it's, in your opinion, it's largely advisory.
I would say that the applicable portions of the downtown plan are advisory. The form-based code itself that we are looking at as well is, I think it specifically said it was a draft. So it was not adopted by City Council.
Okay, it's not controlling.
It's not controlling.
Thank you.
But may I ask a question?
Are there other questions?
I just have a follow-up on that point, which is that council agrees with me that the reference to the plan for downtown Evanston, using the words, each plan development shall be compatible with, ellipsis, plan for downtown Evanston, is in the zoning ordinance, correct?
And do you know whether that was passed
It is in the zoning
prior
ordinance.
to or after the downtown plan was
Well,
adopted?
it references,
Chairman Peters, if I may again, I think there's a distinction that we need to make. So downtown plan, when we have a downtown plan, it has a lot of recommendations, a lot of things that we would like to see happen. The implementation is another portion, kind of part two of these plans. And so while City Council may adopt this downtown plan, then at that point, the Plan Commission staff gets together to decide how this implementation process will work. There was a zoning text revision that was provided. Plan Commission reviewed it. It's actually different than the downtown plan recommendation that was provided in the 2009 document. There was a recommendation for adoption from the Plan Commission's perspective, and then the City Council didn't adopt that recommendation. So at this point, we need to be using the current zoning ordinance that the City of Evanston uses.
I guess I'm not
Mr.
so
Ford,
concerned.
do you have questions?
Forgive me, Counselor. Yeah, Mr. Chairman, I do. I want to be sure I understand this.
Mm-hmm.
The Planning Commission early in 2011 recommended the adoption of a form-based code.
That is correct.
That recommendation was submitted to City Council?
City Council did not adopt that form-based code.
Did City Council vote to not adopt that form-based code?
City Council did not. From my due diligence, I looked at a lot of the meeting minutes, and they did not vote on the new form-based code.
Thank you.
Mr. Krakauer, do you know whether a building with no site development allowances could be built without consideration of the public benefits section under
Yes.
our code?
It could.
Do you know whether a building of a size which is permitted would require a PUD under our ordinance?
It may. I think my whole point was, Mr. Chairman, not that you can't have a special use PUD and the property can't be developed. It reasonably can be and probably will be. I'm simply suggesting it's non-compliant with the public benefits, but it could be brought into compliance by reducing the land use intensity and asking for less modifications. It would be a much less severe thing, and it would work. It would comply with the plans. It comply with pretty much the zoning. So you can still do it. It just has to be done properly.
Now, as you tell me a little more, you talked about cumulative impact, and you described several large buildings in the area. Is that correct?
Yes.
Is it your testimony that additional large buildings in the area would have a negative cumulative impact without regard to the design of those buildings?
No, the design obviously is important, but what I was suggesting, and it's a common part of zoning, that we always talk about a cumulative impact, that if we build one, then someone's going to say one another and another and another. What I was saying is this building is going to go on one side with some adversity to One Evanston, even though One Evanston's much bigger, and that will provide a cumulative effect, creating a similar building on the other side, because you know exactly what's going to happen. Someone's going to pick up that piece, and then what's going to happen is One Evanston is sandwiched in between. So if they think they got a problem now, and that's for the appraisers and others to determine, and yourself, if there's a problem now with one building, I think it's on the north, you're going to have a similar problem on the south. So what you're doing, you're setting up the ball field by approving this project with this intensity. So the point is, if you're going to approve a development like this, it's critical that it be approved in a manner that's reasonably consistent with the underlying zoning. Not precisely the underlying zoning, but something more consistent than what has been presented to date.
So your testimony is that a building which might change the trend of development is an adverse impact, a cumulative adverse impact.
No, this building. Not any building, this building. This building, with the way it's designed, with the lack of parking, with the high density, creates a negative cumulative impact because something comparable is going to happen on the other side.
Do you know, without development allowances, the number of units that's permitted on this site?
I think it was 73 units.
I have nothing else. Anyone else?
Mr. Krakauer, your testimony is that this building in and of itself will necessarily cause other buildings to occur in the neighborhood?
I
That it
can't
will
te-
be this building's fault when others are built?
It's not this building's fault, but it's setting a precedent. If you build a building as proposed, I think there's adequate precedent to build a similar building on the other side of One Evanston.
Mr.
And
Chair,
only time will tell.
I have to ask this question. Mr. Krakauer, are you aware that the downtown plan seems to call explicitly for another tall building on the south side of One Evanston?
I am. Yes, I am. I've read the plan.
Anyone else? Stuart?
Mr. Krakauer, did I understand you correctly that this project can go forward irrespective of whether any of the public benefits that you referred to are met? In other words, there need not be a showing of public benefits for this project to go forward.
The zoning ordinance says there should be. That's your local law. But however a commission wants to move ahead, they're welcome to do so. And a city council, isn't this a home rule community?
Yes.
A city council can do whatever they want to do. But there is a reason there's a zoning ordinance, and it's best that it be followed. So you can do what you want to do, but there is an underlying zoning, and there's a basis for it.
Is it your testimony that all of the public benefits listed must be provided?
No.
Would you direct my attention to that portion of the zoning ordinance that requires public benefits before a project such as this can be met?
I think we had that up.
Well, is there something that says explicitly that?
Well, there's the chart, and then the last thing I talked about was section 611.110, which is entitled Planned Developments.
All right.
And the way that starts out, it says in the downtown, this is your zoning ordinance, In the downtown, planned developments are allowed as special uses in D1, D2, D3, and D4. So this is in the right district. In addition to the general requirements for planned development set forth in 636. So you got to get over that hurdle of 636. And 636 takes you back to planned development public benefits. So what they're really saying, and this is common in planning, what I'm saying is planners all over the United States will tell you the same thing. Planned developments were intended to allow a developer flexibility in his development process so he would create a structure or structures of excellence, far better than he could do under the conventional organic zoning. But in turn for that, there was supposed to be something given back to the community. That's the whole purpose. The whole process in the Chicago metropolitan area has been perverted for the past 10 years. It's been misused so much, nobody even knows how to use it properly. And I can tell you because I've used it improperly. So I'm not any better than anybody else, but I've done a lot of, hundreds of acres, thousands of acres of residential development. And I'll tell you one other thing too, I probably shouldn't tell you this. Every residential development that I have done, every single one over 40 years, that's bigger than 50 acres, we have gone in, asked for more density because we knew that the planning staff or somebody would be perceptive enough to cut it back. Every single one. So that's my practice. And that's pretty common. If you go to planning commissions throughout Chicago metropolitan area, every one of them will tell you the same thing. Yeah, we see 100 acres, 100 units. You're not getting it, you're getting 80. But they're stopped at the door. It never gets this far. This one got real far. Thank you very much. Is there anything else?
Thank you, Mr. Krakauer. And may I just get clarification, Mr. Chairman, as to when the cross will happen? After each witness or at the end, cumulatively at the end?
Let's do it after each witness, and then if you have something at the end, you can recall the witnesses, and we'll try and get everything in the record.
Thank you. Winthrop Club 1 Evanston's next witness is Bill Kokalius, AIA. Mr. Kokalius is an architect. He's a principal with Axios Architects, and he is put together a series of studies and pictures and charts, mostly responsive to the Plan Commission's expressed concerns at our last meeting regarding impact on 1 Evanston. Mr. Kokalius.
Good evening, everybody. My name is Bill Kokalius with Axios Architects. I'm a licensed architect, Illinois and other states. I have my own practice. I have about 14 architects in the office. We've done hundreds of residential projects in the Chicago metropolitan area.
Mr. Kokalius, were you asked to undertake any sort of assignment in connection with this application and tonight's hearing?
Yes, I was.
What were you asked to do?
Well, I was here at the last meeting, at the last hearing, and Commissioner Ford asked if diagrams could be provided that would illustrate what the east, west, and north views would look like if you were standing in various points of the units on the 6th floor, staring at the proposed development.
And did you undertake that assignment?
Yes, I did.
In the interest of time, can you briefly tell us what you did to undertake that assignment?
We first constructed digital models of existing and proposed buildings based upon materials provided to us by the building across from us with the actual dimensions and heights. We then went out to the site and took photographs of current views looking out from Winthrop Club through several units. We matched these photos with perspectives generated from the same points in a digital model. This created an accurate and unbiased composite after image that illustrates the view after the proposed new building would be built. The process was used to provide before and after views showing the visual impact from the units on the 6th, the 8th, and the 12th floor.
So basically, for us laymen, you and your colleagues went to Winthrop Club, correct?
That's correct.
Took pictures.
That's correct.
And then we're able, based upon 2 scale diagrams provided by the applicant as part of its packet, create an image of what it would look like to scale from the various points of your photographs.
That's correct.
Okay, would you please turn to the first slide? Can you please describe for us what this is?
We're in,
But let me ask, just to put it together so it goes faster, and describe your keys and so forth, and we won't do that with every picture, but tell us about this slide, and then we can move from there.
this is a picture from the living room. The site key plan basically shows where Winthrop Club is today and where the new proposed building would be located in the future. And then the unit key plan is approximately where the picture was taken.
So with the site key plan, it looks like you're looking down at the Winthrop Club, which is towards the top, right?
Well, we're looking straight out. What we wanted to do is make it as unbiased as possible, get in the unit and look through the window, not in front of the window, about 5 to 6 feet
No,
back.
what I meant is, looking at your site key plan, with the red arrows, that would be as if you're looking down on Winthrop? And you're just showing where on the building, east to west?
It wouldn't be down, it would be just straight out.
I'm talking about looking east to west, the arrows, so that one would be more towards the west.
Yes, correct.
And then for the unit key plan, you're looking at sort of the middle of the unit, right?
Yes, correct.
Okay, let's go to the next slide.
Okay.
What does this illustrate?
So what we did, we digitally modeled the proposed structure, and we took the views from the unit through the digital illustration. So it's basically the same picture, and there's even shadows because our program showed it. We wouldn't have any shadows, but there would be shadows casted on the building across. So basically, this would be your view from Unit 607 if that building was built, if you look straight out the window.
And you're standing not at the window, but rather a few feet back where normal people would stand in their room, right?
That's correct.
Let's please move to the next slide.
This is Unit 608.
So from looking at your site key plan, it's more in the center of the building?
Yes.
Okay, go ahead.
This is another view, digitally modeled, with what the view would be standing from that room.
So now we're looking at, this is what we would call the after shot. This is the after shot from the middle of the building on the 6th floor.
That's correct.
And the next slide, please.
This is Unit 610, which is moving towards the west from the key plan, and that's the before and after shot.
So the big red building is the one that looks like it's coming right from the living room of Unit 610.
That's correct.
Okay.
This is Unit 808, which is again in the middle, one of the tiers in the middle.
And you just chose to go up a few floors?
Yes, I did.
Because the commission asked specifically about the 6th floor, right? Correct?
That's correct. We did a couple other floors.
Okay. So this is the before, and let's see the after.
And that's the after, yes.
So if you lived in Unit 808, this is what your view would look like if the proposed development is put in.
That's correct.
And finally, we go up to 1207. Why did you choose the 12th floor?
We chose the 12th floor to see what the impact would be, even higher, to see what it would look like.
And have you ever been in this unit?
Yes, I have.
Does that accurately reflect the view as photographed?
Yes.
Okay, let's see the next slide. So we're in the center. This is the after shot.
That's correct.
And we're in basically the center of the building all the way up on the 12th floor.
That's correct.
And that's how it would look out of looks like from the unit plan, the far, I don't know, east or west, but left-hand room within that unit.
Yeah, it's the master bedroom.
So that's the view from the master bedroom on the 12th floor.
Yes.
Okay, can we please go to the next slide? Okay, this looks a little different than what we just saw. What do we have here?
Basically, what we did, like I said before, we modeled the building that's being proposed with the Winthrop Club, and we tried we did it in 3D.
So this is your computer rendering based upon two scale drawings that you had?
Yes.
Of the proposed building juxtapositioned to the Winthrop Club, correct?
That's correct.
Can you please go to the next slide? All right, now this looks like it has a lot going on. What is this?
Well, the white mass represents what is allowed in terms of base height, overall building height, and tower setbacks according to the downtown guidelines. This mass was combined with the proposed project in order to illustrate the scope in which the allowable is being exceeded.
So what's in white blocking there? Now, help us out, because this is a little hard to see. Is there like a dotted or a dashed line that runs across the top of those two?
Yes, there is.
Okay, what is that? What is that supposed to show?
That's supposed to show that the box on top, where it shows 85 feet total, just continues to the back.
And you left those dots in there, though, so you could see the building.
Yeah, because the white slices inside the building.
Okay. So theoretically, those two on the second story, where it says 85 feet, those two would come together to form, right?
Correct.
And the rest of it that's above it is is what exceeds the downtown plan guidelines. Is that right?
That's correct.
And next slide, please.
This is another view from the other side, looking southeast. Building, the proposed building with the Winthrop Club also.
And finally, which I believe is your last slide. Next slide. Could you explain what's rendered here, sir?
Again, the same thing. It's the downtown guidelines, basically slicing through the existing building, just to show a sense of scale with the downtown guidelines.
Were you asked to perform any other assignments in connection with this?
No.
Thank you. I have no further questions of this witness.
Don't go away. Maybe someone else has questions. And anyone have questions of the witness? Us and then Cross.
Your illustration here, you said it was done in accordance with the downtown guidelines. You're showing the massing?
I'm showing the massing, correct.
Yeah, okay. Does that reflect the same, is that the same as it is with the current zoning, which I think we determined is what governs?
I had other slides that I had prepared for that, but that was, because there is no parking here. When you add parking, the building becomes taller, but there was no parking provided here, so that's why it's only 85 feet.
Oh, okay, but so this also reflects the current zoning, not the downtown guidelines, but the actual zoning ordinance allowable massing?
No, it does not.
Okay. Is the current zoning taller, wider, or
It's actually, I
similar?
think it was smaller because there was no parking provided.
Okay.
Well, no parking provided in the proposed building, but is it not the case that the proposed zoning would permit parking? And if the developer were to build under the existing zoning with the 4 stories of parking he is allowed, what would this drawing look like?
It would be taller,
How much?
40 feet, 4 stories,
Or about 120 feet rather than 80?
85, yes.
And the Winthrop Club is how tall?
About 145 feet.
Thank you.
Under the existing ordinance, a building could be built that is not aligned in the same way as what you're showing. Is that correct?
Repeat the question?
Under the existing ordinance, assuming parking is in the building, and that was advocated by the prior witness,
I didn't assume any
the
parking.
building would not have to be aligned mostly north-south as this is, but it could be constructed east-west.
Yes.
And what effect would that have on the views compared to something that's north-south?
There would be more impact than it is today. I did a study on the number of units. There's 54 total units that face north. Tiers 607, 608, and 610, that's approximately 30 units that are affected a lot about 24 units are not as, the corner units on the buildings, they're less affected.
Go ahead.
So you're just talking about the north-facing units, but what the total number of units within the building, what percentage is affected? I mean,
I'm not sure exactly how many units in, what,
I don't think that was within the scope of what we asked him to do. Now, you're free to ask whatever questions you deem appropriate, but I'm not sure he looked at any of that.
but we're talking about the effect of the entire building. I mean, you're doing this on behalf of the Winthrop Club, right? And then also, you know, the impact on the area.
Yes, sir. And I'm not a witness, of course, but our understanding of the commission's request was to provide an accurate portrayal, rendering of the impact as proposed, not with parking, not under current zoning, as proposed on the north-facing units, and that's the bulk of what Mr. Kokalius, I think, accomplished. With respect to this, I don't want to speak on his behalf. Mr. Kokalius, did you try to create renderings of every conceivable design of a building under various zoning restrictions, whether it's the downtown code, the underlying zoning, et cetera?
I did some studies, but not extensively.
Is the purpose of these composites, these ones that you're being asked about, solely to show the excess for the development as proposed without parking, simply to show the excess over what the downtown plan would allow?
That's correct.
And nothing more?
I think someone on my left has questions.
You looked at
You better turn on the mic because people are at home listening.
Okay. We were looking at Unit 607 and 808 kind of extensively, but if I understand that diagram, you would have the same view even if the building was built to 85 feet. You're looking at it out of an 8th floor unit, 6th and 8th, and we're talking
That's correct.
10 feet. So regardless of how tall that building is, you'd still get those same views,
That's
even
correct.
if it was in compliance.
That's correct.
That was my point.
Anyone else on the commission have questions? Does anyone in the public or the attorney for the petitioner have questions? And the public is very quiet. Thank you very much for your testimony.
We have two more witnesses. I think they're both fairly short, but Mr. Chairman, if my memory serves, we are almost exactly the same time as we were last time when we took a break, and might I suggest a 5 or 10 minute break? At your discretion, of course.
Commissioners, is that okay? You're welcome to, let's go in recess and convene back in 10 minutes. I believe there are additional witnesses present.
Yes, we are. Thank you, Mr. Chairman. Our final expert of the evening, on behalf of the objectors, is John Satter. John Satter is an MAI. He has been an appraiser for dozens of years, worked on hundreds, if not thousands, of projects, both on the North Shore area, specifically including Evanston, as well as Chicago. I'll let him talk a little bit about that, but he is basically here to discuss the impact of the proposed development on not only one Evanston, but the general surrounding area. Mr. Satter, is it as warm up there as it is down here?
I apologize for taking off my jacket. It's a little warm in here.
Would you please just briefly introduce yourself and briefly comment on your qualifications?
Of course. Mr. Chairman and members of the board, my name is John Satter. I am a MAI member of the Appraisal Institute, professional real estate appraiser for 22 years. I've practiced in Chicago. I've worked for several firms. For 15 years, I had a practice in Wilmette, where I was very active in a full-service firm, providing opinions of value, for residential properties, also commercial properties. The last 3 years, I've been the managing director for Hilco Real Estate Appraisal in Northbrook, a global advisory firm, and my responsibilities there have been to service clients and render opinions of value on a national basis. Specific to Evanston, over my years, looking at a log, we've appraised over 400 properties in the residential side, numerous commercial properties. Been involved, done some work for the city in regards to vacation assignments. Recently appraised the former Kendall College site. We appraised the former varsity Evanston Theater, where the Gap now is, and have experience with the downtown area. I live in Glencoe, Illinois, and my wife grew up in Glencoe, which is why we're there. But have a strong familiarity with Evanston.
Mr. Setter, were you asked to undertake any assignments in connection with the application before the Planning Commission tonight?
Yes, I was. I was hired by the Winthrop Club Condominium Association to help them understand the impact on value that the proposed development would have on their residential units on the north side of the project.
And did you perform that study?
Yes, I did.
And was it reduced to a report dated November, excuse me, it appears to be dated as of November 17, 2014?
That's correct.
That packet, or that report is part of the packet as far as you know?
Yes, it is.
And it's before the Plan Commission?
Yes, it is.
And so that report really contains all of the analyses, assumptions, summaries, and conclusions that went into your work?
Yes, sir.
Okay. So I only want to highlight some of that tonight. If I understand correctly, however, Mr. Maroos, who we heard from a little bit earlier, is also an appraiser to your knowledge?
Yes.
And he prepared a report?
Yes, he did.
Did you have a chance to review that? And if so, did you have any critique or comments on it?
I did have a chance to, and I did review the report, and I have a few disagreements with Mr. Maroos in a couple areas. Primarily, I believe that his conclusions regarding the zoning are inaccurate. They don't necessarily follow, based on testimony you've heard earlier. Mr. Maroos provided a unsupported absorption study discussing whether or not Evanston even needs this project. There's no real clear fundamental market analysis, supply-demand study, where we're looking maybe at population growth, employment growth, the drivers for why you need more units, or demand, and the supply. What is the existing supply? He did not quantify that in any fashion to give you any kind of perspective on how many units you have in the downtown market area. I provided that information in my report, which you hopefully have had a chance to look at. So I disagree with Mr. Maroos on that point. Secondly, I disagree with his conclusion on the impact on value that a partially obstructed unit would have compared to an unobstructed unit. Mr. Maroos provided.
Did he provide some sort of match pair analysis? Can you explain what that is, and if so, and if he did, your comments on it, if any?
So Mr. Maroos provided a match pair analysis, which I'm sure you've looked at. The match pair analysis compares the sale price of one unit to, in this case, two others. The idea being to try and see whether or not the impact on the view is going to be adverse, trying, if you can, to hold as many other variables constant. And based on his analysis that he provides, he does come up with about a 2 to 3% difference in, or diminution in value for the unit that has the impaired view. Now, I had the benefit of actually getting in that project and took a look at the units. What I will tell you is that what's represented in his report is a little misleading. There is only, the views that he represents as being the obstructed view is of course the view that he says it is. There is, however, a view looking directly east that is unobstructed from that same unit. So it's not as bad of a unit as he makes it out to be. And secondly, the corner unit, the controlled or maybe the higher value unit, which should be the higher value unit, does tend to have an obstructed view. When that was built back in 2002, Sherman Plaza wasn't there. and they oriented the balcony for that unit to the north. And so if you want to go out on your balcony in the O2 tier, you get to get a really nice look at Sherman Plaza and then the bank building right to the northwest or northeast. So it's not really the best data set, if you will. However, that's not the main factor with why I disagree with Mr. Maroos.
Can I ask you to hold on for 1 second? Just so that this is clear for the record, I'm going to ask you to identify what's up there in just a minute. But with respect to the match pair analysis, and this is for the benefit of the commission in its review either tonight or in the future, are you speaking of the match pair analysis that Mr. Maroos did, which are contained at pages 17 and 18 of his report?
That's correct.
Okay, so that's just for the benefit of the commission as well as, and that's what we're talking about from the Maroos report. Please go ahead and explain what's on the screen and what concerns you most.
So what is on the screen are the two units in question that Mr. Maroos poses in his analysis. The unit on the left is the 710 or the 10 tier, which has the obstructed view. And as you see in the upper left corner of that unit, that's called family room, really, they kind of use it as a dining room. The great room, if up is north. And that is the image looking out that window that you get in his report. But the balcony for that unit actually is to the right, and so it faces east. It actually has a fairly good view, although it is a little bit obstructed by the way the building is oriented. Now, the unit to the right is the O2 unit, or the corner unit, which, as you see, the terrace faces north. And so it does tend to look right into Sherman Plaza and have somewhat of an obstructed view. Not as good, Gary, I will agree that the O2 unit has a better view, but it's not like it's unobstructed.
Just for the record, you're referring to some plans for units. Could you tell us again which units they are?
I'm sorry, this is the 10 tier. So in his report, he uses unit 710.
Oh, is that unit 710?
This would be the floor plan for the 10 tier. So all the units on floors. No, we're talking about Mr. Maroos.
We're talking about somebody else's report in a totally different building.
I'm trying to figure out.
I'm sorry, this is 1580 Sherwood.
So this is
Sherman.
This is the
1580 Sherman.
comparable that was used by Mr. Maroos.
Exactly.
And the one on the right is?
The one on the right is unit. There's two units that he uses, unit 802 and unit 1002. So as you see.
So on the right is an O2 unit?
This is an O2 unit.
Okay.
Correct. And now if you look at them kind of together, I mean, it's apparent, I think, to the naked eye that the one on the left is a little bit bigger than the one on the right. And documentation that I obtained from the building manager, and we actually found that the 710 tier, the 710 units sold in 2005 on the MLS, and the floor plan size is listed at almost 1,400 square feet. Now, Mr. Maroos estimated it at 1,100 square feet. So the 300 square foot difference is very significant when you're talking about a 1,000 square foot condo.
So just for us laypersons, that means that variable that he was trying to hold steady at about 1,100 is in fact off, correct?
That would need to be accounted for in the analysis some way. Because I think you'd say, well, look, you could buy this unit for 330 and have 400 more square feet, and maybe the view's not so good. Or you could buy this one right here for 335, and it's much smaller, and it has a little bit better view. So I just don't believe that, so I differed with Mr. Maroos on that point.
On his match pair analysis.
Match pair analysis.
And the primary basis, well, go ahead. The primary basis has to do with the square footage that he relied on, which is incorrect. Is that right?
That is correct.
What else did you undertake in connection with your assignment?
So we undertook the task of just looking at the market data to determine, how much or whether or not, if any, view amenity affects condo prices. And we looked at it in three ways. We found a case study downtown in the city, which we all know is different, but it's a pretty good example, and it's in the report, and it's fairly lengthy. But the nuts and bolts is, condo with a great view, great pricing, Across the river, new proposed project going up, and it's going to really just block that view very significantly. Price values significantly underperformed the market, and in some cases, people actually lost money between 2011, 12 purchases and 2013, 14 sales when the market was appreciating at a very, very good rate.
Let me just ask you, is this case study you used what most anybody who reads the newspaper knows is the Wolf Point project that's been proposed on the Chicago River downtown?
That's the case study, correct. That's
Okay.
the River Bend.
So let's just, in the interest of moving along, can you just briefly describe what a case study is and what your conclusions are, and anybody who wants to follow up in the report can do so?
So in this case, we looked for sale, resale of units. We found 4 examples where units sold in 2011 or 2012, kind of right before the project was gaining traction, and then resold in 2013, 2014, after it was clear that the city was going to grant the project. And so in that case, we were able to find, and looking at other market data and support, able to conclude that the diminution in value of 2 of those units ranged somewhere between 9% and 36%, with an average near 20%.
That diminution of value you attribute in this case study to the impairment on the views, is that correct?
That's correct.
Okay. And that's what you're focused on here with respect to the Winthrop Club 1 Evanston analysis? Okay. Did you prepare any slides that you'd like to highlight to the commission that perhaps if you could just ask us to move along, we can, and we know you.
These are hard to see, but, here is the River Bend project, and here is the site where the new Wolf projects will go up. The next slide shows a little bit of the same information. The bottom slide shows you the view from the unit, one of the units now, or maybe about a year or so ago, before construction has begun. And the next slide, I believe, will show you, here's a view from the other side at the 333 River Bend project. And here is where the new buildings are going to go up. There's going to be 3 towers that are going to be about this tall, and they're going to go 1, 2, 3. So these people who had these beautiful city views, and now they're going to be gone, they suffered a loss. We also took a look at match pairs sales in Evanston, and there are a lot of buildings around downtown, and one of the problems is trying to hold all of the variables as constant as possible. So what we did is we looked at 2 projects. Can I get the next slide? Next slide. So we looked at 2 projects that were in proximity to large, tall buildings. So here's one, 1720 Maple. And now across the street over here, you have the theater and some taller buildings. The brokers that in the community that we spoke with said, look, you've got to be, I think, at least on the 10th floor for 17 Maple to have a clear view over all this stuff over here. And so we try to find units below 10 and above 10, and then just kind of compare them, trying to hold as many other factors equal or equate for other differences. And we also did the same thing in 800 Elgin. So 800 Elgin is an optimum building here, and right next to it is 1800 Sherman, which is an office tower. So you could find units, again, below the 13th floor, you're obstructed. Above the 13th floor, you see over it, and you have a fairly unobstructed view. And so, again, trying to hold variables constant, we found units in the same tier, same floor plan, same size, trying to equate for any differences. In this case, the diminution of value ranged 10 to 25%. Initially, and adjusting for those factors, we concluded a range of about 13 to 25%, with a median near 16%.
And that's
difference in value. Just
from what?
For view amenity, and trying to equate for floor height. Floor height and view amenity tend to kind of get intertwined. And the last thing we did is, during the course of these analyses and talking to all these brokers to verify this data and find out, hey, did your client sell his property in River Bend because the view was going to be gone? He's like, yes. And did you think you took a loss because of that? Yes, we did. And they were all very unhappy. Some brokers thought that once the new towers go up on Wolf Point, that it'll be an accepted view and that it wouldn't be so bad. So we had a range of influence. But the brokers that we spoke with in the North Shore that we called to confirm our sales data and gave a range on view amenity. It's kind of the same constant, right? You have a unit with a good view, and then you have a unit with an obstructed view. Can you give us some feel? The range was 7 to 20%, with a median of 12.5%. So all three of our analyses kind of bared out some expected loss in value, just the fact that you're going to lose your view amenity, because it's such a big driver for why, residential condos sell. People buy condos to live in them and have a view. Nobody wants to look at a brick wall, and nobody wants to, be within 50 feet of their neighbor. The view amenity is a very critical part of why residential condos sell and why they sell for a lot. So in that sense.
Well, let me just ask you, did you reach any final or summaries and conclusions that are contained in your report?
I did.
And they're contained at page 20 for the benefit of those who, this is now the Hilco report. They're contained at page 20?
On page 20, yes.
And was it your conclusion, and this is a summary and conclusion, and I'll let you explain them, that the diminution of value due to the proposed plan development that is the subject of tonight's hearing ranges from approximately 10 to 20%? Is that correct?
That's correct.
And that is based upon the work you did in terms of the case study, market pair analysis, and survey of market. Is that correct?
That's correct.
And that's a substantially higher percentage of diminution than Mr. Marous testified to, right?
It is higher, but I will add that, when we adjusted for differences in floor, now we did one paired analysis where we used a unit, and I don't know if you can get that slide back up, but in the 800 Elgin building, where one unit, they have a little bit unusual balconies, so they kind of actually angled the balconies north, so you don't have to see the 1800 Sherman building on your balcony, which was smart. So these little these little orange balconies here, right? So they actually face north and they face south. And so we looked at what the value difference would be between one on this side and one on the west side, just as a, or no, I'm sorry, I apologize. For one on the north side, same, kind of floor plan. Slight difference in square footage. So in that case, we used about $125 a square foot to adjust for differences in value. I mean, these condos sell for about $200 to $350 a square foot, depending on how big they are and how nice they are. So in this case, we use about $125 as prices get bigger. That would apply about a $38,000 or $40,000 difference in conclusion for Mr. Marous's analysis, which if you divide that by his price would be roughly 16% in loss in value, using his data. And using data that, that I confirmed with the brokers. I was there. I got in those units, in similar units.
And so would you just finally, just for the record and briefly just summarize and state your final conclusions as contained on page 20 of your report?
So in my opinion, the proposed development will unreasonably diminish or impair established property values within the surrounding areas, and will in general impair the public health, safety, comfort, morals, or general welfare of the inhabitants of the city of Evanston.
In reaching those conclusions, is there anything in addition to that which was in your report and that to which you have testified tonight that you'd like to add? In other words, anything further?
No, sir.
Any further testimony before we do cross?
I believe Mr. Satter is prepared for questions from the commission.
Commissioner Ford.
Mr. Satter, you just cited, I believe, one of the standards for the special use and the general standard for zoning, health, morals, general welfare. Can you tell me in your professional judgment how this building negatively affects health, welfare, morals, and the zoning language, apart from any diminution in value of adjacent properties?
It's my opinion that the lack of the parking on that site will add to safety issues surrounding that property. Look, I'm as guilty as anybody else. When I can find a free spot to park for 5 minutes, I'll go in there, I'll just park it, and then I'll cut back out. I have a parking garage at my office building. I do the same thing. I'm not supposed to park in UBS's slot,
My question,
but I do
Mr.
it.
Satter, had to do with your professional judgment as to those issues?
Well, my professional judgment is just, again, looking at the parking issue. And as, you know, we do analyses of projects, parking compliance is one of those standards that, you know, that we discuss. I'm not a zone expert. I won't, you know, tell you I am, but we do look at those things when we do valuations.
Thank you.
We want to know whether a project conforms to zoning.
So just so I'm clear, you said that it'll diminish, your summary said it'll diminish all property values in the area, but the evidence you provided, I think, stated to simply the units affected with view. So does it affect the property values of the south-facing units in the
In this case,
building?
I would say it would not.
Or the corner units that have the similar better view as you provided as evidence from the Optima building, the Sherman building, that have another angled view that would be unobstructed by
I
it?
think they would be impacted to a lesser degree, toward a lower end of the scale.
Okay.
Following that up, you've spoken about units in One Evanston. What would be the impact on property values of adjacent properties to the north and the west, across Davis Street and across Maple Avenue?
I think that to the north, the tracks cut in pretty quickly, and you have just some.
There's
lower-
retail property
there's
there.
Right, there's like low retail properties there. There is a 6-story, 7-story residential condo project to the immediate west of the site that would be impacted as well, maybe I would believe.
Impacted how?
Impacted adversely, their site, their view amenity would be diminished.
What about the retail properties, commercial properties in the neighborhood?
I don't believe they would be impacted.
Either way?
Either way.
Didn't someone testify earlier on cumulative impact that in fact this building would tend to provoke the development of other buildings, which presumably would involve an increase in the property on which, value of the property on which those buildings were built? It seems to me that the cumulative impact that was described earlier translates into an increase in property value on adjacent properties. Not so?
That's a good question.
Thank you.
And really, you know, I could speculate on that in a broad sense. You know, we certainly try to always do research before we give any opinions of value and make sure we have everything supported. That's a good question. You know, one of the factors, I guess, that would influence that would be whether or not they're going to get the same goodies that, you know, the gentlemen are asking for this evening. Land
Mr.
value tends to
Krakauer,
be,
I think,
I mean,
testified that they would.
My question, I mean, you know, to the developer would be, well, does he own the land yet, or does he have this as a zoning contingency, and he's not going to? So it's a contingent value. It really, you know, you have to say, well, look, he's paying. Let's just say, you know, it's listed for $1.8 million. Let's say he pays $1.5 million, but he's had this whole contingency period. He's not going to get hurt. He maybe lost some hard money, some option money, but that's going to have. That price is going to maybe be a little bit inflated, right? It needs to be considered whether or not that's the actual real market value of that land, or is it because of the fact that he was able to obtain all of these benefits that he's asking for? So would it rise all, you know, all with the, you know, do all boats rise with the tide? That's a good question. But I think that there's certainly some surrounding parcels that that would be large enough for a project.
Other questions? Go ahead.
So we've talked about views and things, and from units high in the sky, but when you walk around that area, and I think probably the units across the street are more impacted by this vacant lot that's undeveloped, is, you know, I think pretty much an eyesore as it is now. How does that affect property values, and how does having this eyesore of this, lot that's not perfectly maintained and things in your area affect local values versus a developed property?
I mean, we have the slides, right, from 6. Can you show the slides from 6? Because 6, I think, is the first floor where you actually have views. And so if you look at the architect's photos, right, I mean, I don't think it's necessarily such a bad view. I mean, having a vacant parking lot next to you is fairly common in the city.
I think the question was not about views.
Yeah, it's not about views. I'm talking about being down at ground level. When you're 6 stories up, every garbage you can't see it. It's small, it's imperceptible. But walking around in the urban fabric, there's this empty lot. Everyone complains about empty, undeveloped lots in residential areas. This is that kind of lot. So how does that affect land values in the areas?
Well, I think that there's no reason why that lot couldn't be utilized presently for parking in some fashion, and it could be cleaned up. It could mean downtown Glencoe, where I live, they did an amazing job streetscaping their parking lot in the middle of town, and it adds to the overall character and vibrance of the downtown. In this case, same thing. Look, it's up to you guys in the village to enforce your ordinance, your appearance codes. I mean, give them some tickets. Have them cut the bushes. Have them, landscape them. Have them make it a viable parking lot. I can't answer you. I think that in general, there's a lot of properties that are in a state of, near the end of their lives that would be targets for redevelopment. I mean, does that mean we bulldoze all of them? No. I think some of them can be enhanced and adaptive reuse to make properties look and maintain some of the original character of the area.
I'm sorry, but I'm not asking about that property. I'm asking about the value of the surrounding properties. What's the effect of vacant, unused land on the effect of properties in the area?
Do I understand the question to be that does this vacant lot and the nature of the land in the surrounding area have a negative impact? And if so, what is it on Winthrop Club 1 Evanston? Is that what you're driving at?
Not about not limited to Winthrop Club.
I apologize. I suppose it would have, it's a temporary effect until until it's developed.
Someone on my left. we don't look left enough.
Okay. Mr. Satter, you said that you felt, in your opinion, the value of the properties, which will now have or would have a restricted view, reduced the value by, 16% on the average, did you say?
That seems to be a
okay, that's a short-term thing, and I want to just ask your opinion. In 5 or 10 years going forward, as property values change, and I assume that they'll continue the trend of going up unless we have another recession, will that percentage change? And if so, which way?
That's a good question. I think that, speaking with brokers, there is a general feeling that as buyers get used to that view, that it become more accepted. And it probably wouldn't have as significant an impact.
Okay. Thank you.
May I ask a follow-up? Thank you, Mr. Chairman. Turning to page 20 of your report, Mr. Satter, I believe it was Mr. Ford, asked you a number of questions relating to general zoning standards. That's the part about impairing the public health, safety, welfare. Do you remember that?
I do, yes.
And one of the commissioners also asked you a question about impact on the surrounding area, correct?
Correct.
Okay. On page 20 of your report, do you reference, for example, the extremely limited on-site parking?
I do.
And so in connection with that, and you made comments relating to how you think that could have a negative impact in terms of traffic, correct?
Correct.
So that plays into your conclusion, does it not, about impact on public health, safety, comfort, morals, and general welfare?
Yes, it does.
So your report actually does address issues beyond just I think you call it the view amenity, so therefore there is basis in your report such as parking for your conclusions. Is that correct?
Correct.
What about the comments on page 20 about locating air conditioning compressors on the roof and cycling through the summer months? Do you think that noise created by somewhere between 60 and 70 units might impair the public health, safety, comfort? Let's focus on comfort of the inhabitants of the city.
I mean, I think that would probably be more of an impact on Winthrop Club 1 Evanston. Sound tends to rise off the buildings, but yes, those. I mean, that's where you have to locate them. I mean, that's just how you build them.
So I'm just asking. So, for example, there is evidence and analysis by you in your report relating to those final two conclusions, correct?
That's correct.
I have nothing further.
I guess now I have to ask questions about this. You aren't qualified on public health or safety or comfort, are you, as an expert?
I'm not an expert, no, sir.
I looked at the report. It's wonderful in a number of respects, but I don't see any studies relating to public health other than, well, I just generally think remote parking is a problem.
That is the main concern for safety.
And you didn't have any studies to support that conclusion, did you?
I did not, no, sir.
And do you have any studies to show that parking further away is actually going to impair safety?
I do not.
Do you have any studies to show the parking is going to impair the general welfare?
I don't have any studies, sir, no.
I know that there are a number of studies that show differences in value as buildings get taller. From the higher is more valuable than the lower, up to some level higher than any of these. Did you make an adjustment in your model so you compare the changes in height? And I'm talking about looking at the 1800 building and how it obstructs the views. Did you do anything to build that into your model? I'm not saying you didn't, I'm just curious.
Yeah, we did. We considered a floor height adjustment.
Would the building across from Wolf Point has a view all the way down the river? It's a spectacular location. Would the data be similar for a building that's not on a river but sort of surrounded by city?
Yeah, I think that's probably a more dramatic example because of the view is so I guess grand and broad.
I don't have anything else.
The thing I would add about that is that those units are similar in a sense to the Winthrop Club in that they only have really one view out.
Anyone else? Any public questions?
Could I ask a question of staff related to one of your statements? So this building would be required to meet sound decibel ratings at the property line like any other developed property?
That's correct.
It would? Okay, just so, okay.
Does any member of the public have any questions? No. Thank you so much for your testimony and the report.
Thank you. Thank you, Mr. Chairman.
Objectors' final witness tonight is, in fact, the president of the Winthrop Club 1 Evanston Condominium Association. I think you all are familiar with Mr. Ellman. He is here to speak on his own behalf, on behalf of some of the residents of the building. And in order to refrain from being overly duplicative, if at all, he's going to confine his comments, driven by some slides, in general to his analysis of the compliance with this downtown plan and his feelings in terms of its impact on this building and its non-existence, really, I guess, before when the Winthrop Club was erected. So, Howard Ellman. All right, Mr. Ellman, could you just briefly describe what it is that you do? Other than handle this matter?
Yeah, I live at the Winthrop Club 1 Evanston building. I'm a almost 28 full-year resident of Evanston, lived in a couple of homes, loved the community, and moved to the Winthrop Club when we downsized and finally got our kids out of the house. For a large part of my career, I was involved in the electronic system integration business. But for the last 10 years, I've been involved in investing in real estate, managing real estate properties. I was president of a property management company called River West Management in Chicago. And so I have some experience managing commercial office properties, condominium associations, and investor-owned residential properties.
And in connection with your, well, let me just ask you some general background questions. When did you first hear about the proposed application, from the applicants, and what was your reaction to it, and what did you undertake to try to learn?
Well, the first I heard of the proposed application when an application was discussed with the city to be an extended stay hotel, because I believe that was the first concept that the developer had. And then it switched to an apartment building. I'm assuming it switched to an apartment building because the extended stay hotel was approved for Chicago Avenue, and there was some analysis done that you didn't need two in the city. But that's just my conjecture. But then I started communicating with Alderman Wilson. I started communicating with city staff. I went in and met with city staff to try find out more about it before the official plan development application was submitted, and began to express my concerns and try to communicate my concerns with city staff. And unfortunately, I didn't do a very good job of that because it didn't seem to resonate very much. The project went on. But during this time, I had a lot of conversations with owners at 1 Evanston because everyone was all concerned about it. And I started researching, and that's when I discovered the downtown plan, which I remember back in 2007 through 2009 when this process was going on in Evanston, because I lived in Evanston. So I read up on that. I started reading up on the zoning ordinances and trying to understand just what was allowed and what wasn't allowed and so on and so forth. And discussed it with the owners at the building, and we decided that we really needed to look into this and hire some professionals to help us with this, because it has a big impact, we think, on us and on the near community, and I think also on the future of development in downtown Evanston. And I think that kind of goes, in my opinion, to what Alan was talking about a cumulative effect, that part of the cumulative effect is it's harder to deny somebody else from doing something once you've let someone do it in the first place. And do we want downtown Evanston to be one high-rise next to another, next to another, next to another? Speaking as an Evanston resident for 28 years, that wouldn't be my vision of downtown Evanston.
Let me ask you, in connection with your professional undertakings in real estate management and so forth, have you had the opportunity to review zoning ordinances or landmark ordinances, municipal regulations relating to real property, things like that?
Yes.
I do this with great hesitation. He's not qualified as a witness. He's being asked for an expert. He's not qualified as an expert. He's been asked for an expert's opinion. Whether or not he's ever reviewed an ordinance or not is irrelevant for his testimony today. They've had experts that testify to that. I would ask that he not be allowed to answer that, or if he does, that the appropriate weight be given, because he is not an expert witness, regardless of how many units he's invested.
I'm not attempting to qualify him as an expert.
I believe it's fairly clear he's not an expert in real estate, and the commission will consider the weight of the testimony by non-experts and the fact that it's somewhat speculative.
Can you read
Commission is capable of doing that.
Yeah.
Can you read a zoning ordinance?
I can read a zoning ordinance, and one of the properties that I was responsible for managing in Chicago was a 180,000 square foot mixed-use facility, which was in a planned manufacturing district in the city of Chicago, and was a lot of time I spent trying to make sure I understood that in terms of the types of tenants we could have, the types of developments we could do there, and so on. So, yes, I'm not an expert, but I can read and I think interpret zoning ordinance.
Okay, so did you do that in connection with this application?
I did.
And did you focus on any one particular ordinance or set of guidelines that the commission also looks at?
Well, what I tried to focus on was the plan development ordinance, the D3 ordinance, and then the downtown plan that was approved by the city council, and which was a update of the 1989 plan for downtown Evanston.
And was Winthrop Club subject to the downtown plan when it was reviewed and approved?
No, the ordinance that approved the Winthrop Club was in October of 2005. Going back and reading the Plan Commission minutes and reading the ordinance, it appears that the period of time that the Winthrop Club was under consideration was almost 2 years, 2004 and most of 2005, before it was finally written into an ordinance in the end of 2005. And then, as we all have belabored, and I have to tell you, there's a lot of me. I hear you ringing in my ears that says if you're covering something that someone else said, there's a part of me that wants to say I agree with everything Alan said, but there are a few additional things that I'd like to try to.
Can you just hold on? Did you focus on the downtown plan because it was a guiding set of guidelines or a supplement to the comprehensive plan that was not in effect when Winthrop Club was developed and is in effect now?
That's correct.
Okay, so what did you just summarize? We know you're not holding yourself out as an expert, but you are the president. What did you find?
I think the statute speaks for itself, and it's appropriate to put the statute in the record without someone reading it to us. But if you have something other than what's in the ordinance, that's certainly relevant. But the commission has copies, and they too can read.
Okay. Well, there was some confusion earlier about whether or not the plan for downtown Evanston was even included in the ordinance, and of course it is, which is what we have up on the screen.
It's a legal question, and this witness is not qualified to give legal opinions.
Okay. Does this development, Mr. Ellman, having reviewed the downtown plan and reviewed the applications plan, adhere to the standards of the downtown Evanston plan as adopted in 2009 by the city council?
Not based upon my reading of it. No.
Okay. Why don't you just quickly take us through as to where it falls short? Go ahead.
And this is all referencing Section 8 of the downtown plan, where they get into some very specific guidelines, and they talk about a maximum base height of 42 feet. With the ability,
let me just ask, you assume that without any implementing amendment to the zoning ordinance, the downtown plan is enforceable?
Yeah, I guess
I'm just asking. That's the assumption.
And the basis of my assumption, and where I have difficulty reconciling some of what I've heard before, is when within the zoning ordinance it says that each plan commission shall be compatible with and implement the adopted comprehensive plan as amended, the plan for downtown Evanston, of which this thing passed by the city council was an update to that plan. And then it goes on to say any adopted land use, urban design plan, specific, and so on. So, to me,
we're comfortable with this assumption.
Yeah.
I mean, it may not be correct,
Yeah.
but I just wanted to clarify that that's the
So
assumption underlying our
that's the
testimony.
basis of why I have that assumption.
You can go ahead.
Okay. And the maximum base height that's listed there is 42 feet, with an option for it to grow to, I believe, 88 feet, with providing extraordinary benefits to the city. Parking is laid out. They're short on parking. It talks about the use of the ground floor being for retail, service, and entertainment uses, and not necessarily fitness room, lounge, party room, and so on. And it talks about a minimum FAR of, a maximum FAR of 3 versus 4.8.
And you put this chart together. I mean, it's not an expert conclusion, simply by taking a look at what's being applied for and what the downtown plan requires, correct?
Correct, right.
All right, let's go on to your final set of questions here.
And then
Go ahead.
The next section of that section of the plan talks about public benefits. And the public benefits that it talks about, it gives specific public benefits, and it gives maximum bonus percentages in terms of base FAR relative to providing those public benefits. And the public benefits it talks about are underground parking and loading, of which there isn't any. Gold or platinum leads sustainability. This building will be silver, so that doesn't qualify. On-site affordable housing, there isn't any. Affordable office space, to my knowledge, there isn't any office space. If there's above-grade parking, it needs to be wrapped with a habitable floor area. That doesn't exist. Landmark preservation, the streetscape and alley improvements, that does deserve a public benefit. There's no public plaza, and there's no facade improvements because it doesn't apply. So based upon that and what's laid out in the downtown plan, the way I interpret it, there should be a 10% public benefit bonus.
A couple of final questions. You're here testifying on behalf of yourself as a resident of 1 Evanston, correct?
Let him finish.
Correct.
And as president of the association, correct?
Yes.
And in part, these charts were put together for the benefit of the commission and sensitive to its comments, so as to perhaps prevent duplicative testimony on these 15 or 20 areas you addressed, correct? You thought you could, with one person, represent a number of the concerns that your membership has, correct?
Right.
No further questions.
Mr. Ford, you have some follow-up questions?
Mr. Ellman, the public benefit summary that you gave us, underground parking, whole building sustainability, et cetera, I believe this is a list that's found on page 71 of the downtown plan.
Okay.
Are you aware that that list is preceded by this phrase, a list of possible bonuses would include? Sounds to me as though this list is conditional rather than definitive. It is, if we were going to do something, we might include this list. Would you read it that way?
Yeah, I think that's one of the problems with the evaluating the appropriate way to apply what's in the downtown plan to this decision. I think that's a very good point, because the problem, there's a lot of conflicting information, because if I read the zoning ordinance, it says that it shall comply, but the attorney says that it's only guidance. So I think that is the problem that we're all faced with. And I guess in my analysis of reading this for a while, what I think is this. I think that plan should be looked at very seriously in terms of evaluating future developments in downtown Evanston. But even if you don't agree with me on that, I don't think the plan should be not considered at all. It was passed by the city council, it was adopted, it's referred to in the zoning ordinance, and I think it requires some careful consideration.
Other questions? Did you put together the charts you referred to and that are in the packet?
Yes, I did.
Go ahead.
This project is a perfect example of why to explain the genesis of the downtown plan. I mean, prior to 2005, from a developer's point of view, Evanston was the Wild West. You could propose anything, and if the city council went along with it, it got done. But in the minds of many, it was too much, too soon, too little forethought went into any development. And that is what began the downtown plan. And it took a lot of time, 3 years at minimum, and a lot of money in consultant fees. But it's now advisory, and it's not obligatory that we follow the guidelines.
I do have a question, and you don't have to answer it because it goes beyond your testimony, I think. Is it your opinion that nothing should be built on this property which would obstruct the view of any apartments?
No, that's not my opinion. And in response to Member Lewis's question about it being an eyesore and living in the building next door, I would love to see something built there. But I would like to see something built there that is less dense and fits in better with the overall neighborhood than the way I think this one will fit. I mean, I think it's vacant land, and last winter I was on the phone dialing 311 because the property owner wasn't shoveling the sidewalk and it was ice and dangerous, and calling the alderman. I would love to see an appropriate development built on that property.
And maybe, did you have another follow-up question? I have a little red light here. Do any members of the public or the petitioner's attorney have questions? Public is quiet. Thank you so much.
Thank you, Mr. Ellman. Mr. Chairman, that concludes the Winthrop Club 1 Evanston's formal set of objections and presentation and objection to the application pending before the Plan Commission.
Thank you so much. It's 9:45, and we have a lot of people here. I think it would be appropriate to take public comment. Commission's ready. There is a sign-up list on the out there, and if you put your name on the list, unless you don't want to state your name, then it'll be easier for the city staff to know who spoke and where they come from. And I was just going to go right down the list. I know there's 6 or 8 names on there, and we'll hear from everyone that wants to talk. Thank you. So we just take a minute. If someone brings the list forward, I'll write down the names and we can just go ahead and start. I'll just write down the names and then we'll make a new list. Yeah. Thanks. So I'm going to take the existing list and give this back, and anyone else can indicate they want to speak. No, nobody identified themselves as mystery person. The first person listed is Joe Roshan. I might be mispronouncing it. I'm sure I'm mispronouncing it.
I'm Joe Rochelo.
Thank you.
So I guess to be truthful, I'm a little bit nervous to say anything after what I've listened to tonight, so bear with me. It's my first time presenting any kind of feedback at a council meeting or plan commission meeting. I'll start just by saying, though, that our home is, we live in a house. It's 2 blocks south of this development at Greenwood and Maple. So I think our perspective is a little bit different, and I did prepare a statement in advance. I didn't write this tonight while I was listening, so forgive me if it overlaps with a few of the things that are already said. But we believe that this proposed project does not adhere to several of the conditions of the special use and/or plan development requirements, and specifically Section C that's already been highlighted, and I won't read it to you, but it has to do with that cumulative effect idea. Specifically, though, and more important, it appears that there are a number of variances being requested by this developer that range from the parking, which is going to be my main concern that I'll tackle in a minute, to the other setback requirements and things that I've read about in some of the news about this. I'm afraid that we think that this, as approved, if approved as proposed, would set a precedent for future developers. And I think the ripple effect and having other developers think that they could come in and get the same concessions could cause issues in the future development of Evanston, which we feel is very important, and we really do support development. So I think that the potential for negative effects on residents in the city is real. I believe we, because of the desirability of where we are and the attributes we already have in this city, I think that we should be strong and stick to our zoning requirements where developers are concerned. So regarding the lack of on-site parking, which is our major concern, and I guess, I'll be honest that our neighborhood already has parking issues. We're close enough to the Y, to the McGaw Daycare Center. A lot of apartment buildings in the area, we know that people tend to leave their cars for weeks at a time. A lot of students that live in the area that we know and are friends with, we already face these issues. I think the proposal to lease space in the city-owned Maple Avenue garage isn't practical or sustainable due to the age of the parking ramp. So down the road, when that parking ramp has to be either refurbished or possibly torn down and replaced with something else, what happens to the parking for this building? Is there something in the plan for that type of an event? It just seems very odd to me that this would be approved after all of the other apartment buildings that are being built with parking on site. I don't know all the rules, I don't know all the requirements for the number of spaces, but I learned some things tonight if those are facts. But that would be my main concern. So I think if people travel to and from that parking ramp from the building, not only for people that might have physical disabilities or elderly people, but I just think the hassle factor in getting from point A to point B, whether it be with a car or walking, makes it a ridiculous notion that that would be valid parking for a building that far away. Further, I think what happens when the next project is with no parking is approved, and whether it's on the other side of the One Evanston building or a couple blocks away, I think that does have the potential to cause even more additional problems if parking is not considered. So I think that one other point on the parking is that if the people are going to have to park there and they find over time that it's a hassle, even though they might have rented a parking space, I think they might have the tendency to spill over into the neighborhood, into the few spots that we have south of this development and west of this development in that neighborhood. And it's just going to cause so much congestion. So I guess that's my main point. In closure, though, I think if the Plan Commission plans on moving forward with it and recommending it to the City Council and it's approved as it currently is proposed, I'd like to talk to one of the developers about my corner lot, because I think it might have some potential opportunities down the road. So that's all I had to say. Thanks for listening.
Does anyone have questions?
Mr. Chairman, a question not for this witness, but for the developer, which this witness's testimony has provoked. May I ask that?
Sure.
I
don't know if this witness can answer, but
well, forgive me for speaking past you.
That's fine.
To the proponent of the project. You're proposing to lease parking spaces in the Maple Avenue garage for the use of your tenants. Will those leases, that parking space, be bundled with the residential lease, or will it be separate? That is to say, will every resident of your buildings lease parking space, or only those who choose to?
you can answer that.
The final discussion on this is something that's been held off, but the answer is no, it would not be bundled. One of the reasons why is even in any of the new rental buildings that have been approved and built here, even if they have 75% of the parking there, those parking spaces are not automatic to those tenants. They have to pay for them separately, and you're not required, even in those buildings, to use those parking spaces. And as we stated, and we continue to state, if you have a car that you need to use every day, you're not going to live in this building. You'll go to another building. for every, yes, it's an assumption. It is an
Okay.
absolutely.
But so
Well,
if-
no, the fact is it's an assumption that we make every day for people who live in highly urban areas. You couldn't be any closer to transit unless you were on top of the train station.
So
but
if
it is
I-
not bundled.
It is not bundled, so that if I were to rent in your building, I could avoid some fee by not taking the parking possibility.
You could. And again, it's based on our assumption that people who use a car on a daily basis will in fact not rent in our building. It's only 100 and something units. They have other buildings to rent in. And Michael McLean.
Michael McLean with the developer. Not only are they not planned to be bundled in the Maple Avenue garage, which is currently about 50% cheaper than the average rental rate on on-site parking for existing Class A rental properties, it would not be bundled on-site either. And due to the location, the cost of construction, our spots on-site would probably be close to double the cost for the residents to utilize the Evanston garage, which would actually further entice them not to rent spaces in the
Okay,
on-site.
well, yeah, that's a hypothetical. I understand. Thank you.
Thank you.
Of course,
Thank you to the witness for allowing me to ask that question around you.
No, that's fine. I'm just.
any questions of this witness relating to his testimony? Thank you.
Here's a question.
Oh, yeah.
I'm not sure you can answer this, or if somebody from the city needs to answer it. Are you in a restricted parking area, a zone?
One side of our, we're in a
Okay.
neighborhood zone F, and part of, just one side of our block is restricted, and one side is not.
Okay, so it's, you get a sticker every year from the city?
That is correct.
Okay, thank
Yeah.
you.
One other point, and I don't know enough about how much that Maple Avenue garage is busy or not, just from observation and having parked there myself or rented a car from Enterprise. But one other concern is that what if those 100 spaces were rented by these people that would rent in this building? It does take away, I think, from the city, whether we're getting paid for it, the city's getting paid for those spots or not, just the convenience and people that come to the movie theater from outside of Evanston or from within the city of Evanston that aren't walkable. I think it's detrimental that way too, that they'll have a hard time finding parking. So again, just from the day-to-day experience perspective, so.
I have tried to find parking where you live, because I have a close friend across the street. Just.
All right.
Mr. Chairman?
Yeah.
I think maybe you just answered my question. Maple and Greenwood, a corner lot, so that puts you across the street from, is it a Lutheran church?
From St. Paul's.
From St. Paul's?
Directly, yep.
Okay, yes. Thank you. I just wanted to get the picture.
Okay.
Yeah, there's daycare at the Y there. There's other witnesses. The next one is Doug Fusen.
Thank you, Mr. Chairman. My name is Doug Fusen. I live at 1570 Elmwood Avenue, Unit 811. After living in Evanston for many, many years, my wife and I moved away when I retired from practicing law in Chicago quite some time ago. Moved up to Wisconsin and spent a number of years away, and moved back to Evanston and bought a unit in our building in the spring of 2013. We like the quality of the building. We love the north-facing view. Like a lot of others who purchased these homes, we were told that nothing could be built on the property adjacent to us that would extend above the level of the parking garage, which is roughly 40 feet, 45 feet, something like that. We were very shocked when we heard about Centrum's proposal, as you might imagine. And I looked into it, as did other people, I suppose because of my legal background, looking at statutes and ordinances and regulations and whatnot, came pretty easily. I will not go into the entire analysis that I presented you with in my written materials that were made part of the packet that is before you all, and I hope you, if you have not yet read through them, at least that you would do so now. I have real concern that the interaction of the ordinances and the plan here is getting terribly confused and potentially to the detriment of the legal solidity of this entire business. It seems to me that where you have an ordinance that says that each planned development shall be compatible with and implement the downtown plan, you're under some obligation to do that. You can't simply say, well, we'll take it here, we'll take it there, we'll ignore it here, we'll ignore it there. That is exactly the same kind of arbitrary sort of behavior that the Planning Commission was accused of back before the downtown plan was developed. They were accused, everything that people were saying, it was ad hoc, that it was unpredictable. In other words, it was arbitrary. And the downtown plan, at least as I understand it from my reading and from what the plan itself says, was designed to get past that. And one of the things it did with respect to this particular property that we're talking about here, the 1571 Maple parcel, is it put it in an area that under the downtown plan is called the West Traditional Area. And that particular area is described in the plan as going to have smaller scaled mixed-use buildings to reinforce the traditional character of the neighborhood. That's at page 48. Another point, it says the post office, the YMCA, and the train stations are major activity generators and activate this 2-block stretch. Maintaining its scale and eclectic character is recommended. That's on the next page. That's the district that this property is located in. And in another place, they refer specifically to saying these traditional areas provide a marked contrast to the mid and high-rise buildings that have emerged in recent years. So the very concept of this building being 13 stories or however many it currently is just flies in the face of the downtown plan and everything that it stands for with respect to this West Traditional District. I don't think that it's hard for me to conceive that there's any argument to the contrary. The words of the thing are there.
Let me ask you if you read page 44, the first line on page 44 of the comprehensive.
I'm sure I did. I don't have the whole thing in front of me at this point.
Okay, I should interrupt. I'm sorry.
That's okay. I wanted to come back to the notion of the downtown plans lowering the height, reducing the density in these transitional zones is reflected in the 42-foot base limitation in the heights of buildings. Now, there's been talk about here about whether with allowances you could go back up to 8 or 9 stories or whatever that was. But the thing there is that the downtown plan says specifically that only projects that provide, quote, extraordinary public benefits get to make any of these adjustments or get to have any of these allowances. Not any public benefit, not 2 parking spaces, not any of the rest of this stuff that's been talked about here. Anyway, I want to close simply by saying that if you're going to have a plan that argues whether you think it's binding or whether you think it's advisory or whether you think it's for guidance or whatever it is, the whole purpose of which is to reduce the density in this particular area, to reduce the scope of the buildings in this particular area, you don't turn around and grant a whole bunch of allowances under the zoning that lets people put in big high-rise buildings that are much higher than the density that the zoning would otherwise permit. And that's what I've got to say.
Are you aware of the fact that preceding the section that you talked about, it is a sentence, following is a description of the character and recommended development approach.
I'm sorry?
The following is a description of the character and recommended development approach for each zone, and then there's a description.
Right.
I think the operative term is recommended, and if the council had passed implementing ordinances, then it would be very clear. But it's hard when it's preceded with that sentence to say it's mandatory at the present time.
What I am suggesting to the commission is that whether or not it is mandatory, it is certainly in the spirit of the downtown plan and consistent with the downtown plan and would implement the downtown plan, which is what the zoning ordinance for planned unit developments specifically requires. Thank you.
Thank you. Other questions for this witness? Mr. Oh my gosh. What does it say? It's someone who lives at 2611 Hartzell, and they don't know the name. Thank you.
I'll try to make this brief. I'm Debbie Magnuson. I've been a lifelong Evanston resident. I've been a top real estate agent in Evanston for just shy of 30 years. I think I'm usually in the top 10 agents. So I drive around Evanston all day long. And while I'm not an expert witness, I'm an observant witness. So my concerns about this are view. I can speak to that, but I think the view would be limited to the people affected. I think the traffic is a real potential nightmare, and I think the absorption rate on the proposed rentals is something I'm not seeing a demand for. So I'll get back to view. And by the way, I agree with everything that Mr. How do you say your name? Krakauer said. I agree with a lot that John Sater said, but not everything. For example, I sold a unit in the 1720 Maple building. It closed April 8th of this year. It was unit 810. Had a view of air conditioners across the street. It was a rooftop view. So not a great view. That sold for $460,000. 6 months later, unit 2210 sold for $577 because it was an unobstructed view. So I think that's a huge difference, and yes, we do have to allow for a floor allowance, but still $117,000 is quite a bit. Now, getting back to traffic, when the Omni went in, I no longer can park anywhere around there showing property in South Evanston. That 700 block of Hinman is just a nightmare because those people cannot afford to pay for parking on top of the high rents. These rents are high, and I'm seeing the same thing at 1717 Ridge. People will not walk down to that garage to park their car. They're just not. They don't do it anyplace else. And I'll have to look and see what else I have here. Traffic. My big concern about the traffic there is moving trucks. Nobody's ever talked about that. That street is narrow now, and it's one way. What's going to happen when a moving truck is there and the sidewalk is widened? I think it's just an impossible thing. When you're talking about renters that are moving maybe every year, are there going to be any rental restrictions that they've got to be there at least 2 years like other buildings in Evanston? Happy to answer any questions. Absorption. It just seems like, and I know Katie Trains is going to talk more about absorption rate, but with 350 units coming on the market and a couple blocks away, and then what's the other building coming on, Katie? I don't know how many more units are there. We are looking at a normal absorption rate right now for rentals, especially in the one bedrooms, and most of those all did come with parking in the same price point. And I just think, fine, if you want to think about this project, what is the rush? We have enough rentals coming on in 2015. Let's just see what happens here. That makes the most sense. You've got the whole community up in arms. Yes, something should be done with that lot, but I'm not sure a high-density rental is the way to go. Because I think the assumption here that all these people are going to be taking the train isn't practical. I have so many clients that don't work downtown. They work north or they work west. They're not just going into downtown Evanston. If they are, they pretty much live in downtown Evanston. Then they're going to go to Chicago if they're living in a one-bedroom. Any questions? Anything else?
That's his question.
So does anyone have any questions?
Sorry.
Hearing no questions, I'll thank you for your testimony, and I'm going to ask Steve Lewis if he wishes to testify.
Right. Sorry for the computer. I ran here from work, and I think if I read through this, it'll be much quicker than extemporaneously. So I own a single-family home 2 blocks south of this development on Maple Avenue, and just a few doors down from the YMCA. You know, it's a daycare center that's been there for years. So developers, understandably, they look at projects through the lens of an Excel spreadsheet. That's their job. And their goal is to minimize costs, maximize profits. This is normal. It's a common tactic. You've seen this over and over. We know this, and we elect and maintain employees of the city to counter this kind of activity. For Evanston, this parking-free development with the beginning of a race to the bottom, surely. Who's next in line to get mine? By opting out of well-vetted community parking standards and expectations of availability of people regardless of disability or age. We actually heard about this theory that people would walk downtown. We go to the movie all the time, live in Evanston, shop, and go to the movies a lot. So we tried this out. We walk downtown. So you go through 2 stoplights, busy traffic. You cross the entrance to a ramp. You walk upstairs. Who's really going to do that if they can just park in front of my house? I'm pretty sure it's not going to happen. You know, Evanston is a special place. I travel a lot for my job. I work for a big corporation up north. Evanston's on an inland sea. We're served by 2 major metropolitan rail systems. We're next door to a great American city. We don't have to put up with this kind of stuff. We don't need this kind of thing in our town. We can be more selective. We all support development of Evanston. I would have loved to aspire to have been down at downtown Evanston, something as dramatic as that. But we're not desperate, declining suburb. We also don't want the downtown to become a dormitory. Unique characteristics provide the city the power to say no to developers' bad deals and unreasonable exceptions that we would regret for decades to come. We heard from Don Wilson, our city council person, that, quote, it could be worse. I mean, what a horrible response. This is a false dilemma to drive expediency. Evanston doesn't need to accept the least bad alternative. I urge you to make the right choice, require the reasonable, community-expected on-site parking that building renters will surely need. Don't send us off in the races to the parking, race to the bottom. Thank you.
Any questions? David, it might be Reynolds or Reynolds. It is. Thank you.
Thank you. My name is David Reynolds. I live at 204 Davis Street. I don't have a particular horse in this race. I'm here because I'm concerned about some very general things that are going on with this. Many of you have been here long enough to remember, or maybe not remember, the reason that we built the Church Chicago Garage. It was built because parking was forgiven to development downtown. Employee parking filled the neighborhood, and when the B district, which was the second restrictive parking district, was put into effect, it created a problem. The city decided they had to build a garage. I think that not having parking in this garage or in this building is a huge mistake. I drove from here to the garage tonight. It was over 4/10 of a mile. Because of the no left turn on Church Street, you have to go west all the way to Oak in order to get to the garage. And you also have to go south, I believe, to Lake Street to get back to the property. So a round trip is probably over a mile. The traffic study says there are 70 round trips a day generated by this building. That's 70 miles of unnecessary travel in a city that's trying to be the greenest city in the country. I'm also very concerned about what are called the public benefits. Leasing of 100 parking spaces in another garage isn't a public benefit when it's something that's required by the zoning ordinance. Most of these public benefits are of very little value. And I think that the city should at least consider a financial equation when looking at public benefits. Developer is getting 28, asking for 28 additional units. That has a huge financial benefit to him. The financial benefit the city is getting out of this is very minimal. And finally, the proposed lease of the parking spaces for 30 years is $84, $85 a month. Certainly, in the next 30 years, parking in the city of Evanston is going to become much more expensive than that. And if, God forbid, you approve this, you should certainly make it market rate parking required for this development. Thank you very much.
Questions of this witness? Thank you so much. Mr. Larson, Mrs. Larson, Miss Larson, someone named Larson. That's me. Thank you.
My name is Janet Larson. I live at 1501 Oak, which is the location of the former City Hall. And I've lived in Evanston since '72, with the exception of 2 years. So I've watched a lot of things happen. And I'm going to approach this from a humanitarian point of view. I used to live in the 8th Ward, and when I came back from this 2-year hiatus, we decided to move downtown because we wanted to be able to walk everywhere. And I think a lot of people who live at the Winthrop Club like their neighborhood too, because it's a very nice one. However, if you consider things other than the view, a brick wall in front of your house, in front of your window, you will not have light coming in. It gets very dark on the north side anyway. It could. They have a lot of glass, so probably not as much. I have a southern exposure, one east window and one west window, and I love it. That was the reason I wanted it. If this wall were to come up in front of me, I'd be ready to leave, but we probably wouldn't be able to sell it. The city should consider the fact that even though the developer wants to lease a number of parking spaces, women probably will not want to rent one. I know of a lot of women who do not like to park in parking garages, day or night. And I don't think they're going to, if we have 50-50, that will not go over very well as the price that they're going to be charged. In the past, I feel zoning has made errors, and probably it doesn't pertain to you because it was a while ago when I lived in South Evanston. We had to have an overhang in front of our front door replaced. It was damaged by the weather. And we had to write a plan for the zoning committee. Several people came by at different times to look at it, and they said it was 6 inches too far out toward the street, and we had at least a 25-foot setback. So we had to make it smaller, which meant that we couldn't get our umbrella up in time before we got soaked by the rain. And the rain also fell on the front steps, which froze when it was a cold time of the year. The other gripe I have about a variance has to do with the property that's south of Dempster, between the pet store and the Jewel Osco. At one point, the sidewalk in front of the pot shop and the jewelry store is about 24 inches wide. And there is a lot of traffic of people carrying shopping bags. And you have to go single file. So this is what happens when you have a simple variance and allow that to happen.
Any questions of this witness?
That's all I have. Thank you.
Thank you. David, may it be David King?
David Quo?
That's it.
Hi there. I'm David Quo, and I wasn't planning on speaking tonight, but in listening to all of this, I have about 3 impromptu things that I'd like to just share my opinions. Let me first acknowledge the lift of 1570 Elmwood. So let me just say that I am against the development as specifically proposed. So a few things I want to articulate here. One, and I want to just augment the parking piece because I think it's been very well explained, at least the positions I want to. But the other one is I think you're limiting the people that would actually be able to live in that building. As been stated, probably older people or people with handicaps aren't going to want to live in this building. It's probably going to be a detriment to women in this building at some level that have cars that are going to want to have to walk that route. I have a wife and a daughter. We walk that route to the movie theaters. You know what? You see a lot of people that are looking for handouts and so forth at times. It's a place, if you're a woman, probably not your favorite place to walk through night. The other thing is just state about the weather. If you see walking with Whole Foods at 8 below or wherever you're going to go, you know what? That to me, again, putting on the common sense hat, it's not going to be optimal. Again, my opinion. The next piece is you look at the rentals they're charging at $2,200 to $3,400 a month for a 1-bedroom. I mean, that to me doesn't pass the common sense. I'm not an expert, but I look at the competition of buildings downtown and I look at the competition of other units in Evanston. I'm not sure people looking at that saying, wow, it's one bedroom, and aesthetically, from what I can see proposed, it looks like the building is shoehorned in the way it's now constructed. I'm not saying a smaller unit wouldn't be better. So I would offer that, again, we need to do something there with them, something. I'm not sure the way it's proposed, again, is going to really benefit Evanston. I think you are going to have a bunch of congestion. I can see people needing to drive around and get dropped off to put groceries. You know, they're going to pull up and you're going to see a lot of double parking with lights flashing where people run stuff in and out. This to me does not seem well thought out. Again, I support doing something here, and I'm not saying that a modified version of this might not work. But as it is, it just feels like they're trying to shoehorn something in that just doesn't pass the common sense test for Evanston. Thank you. Any questions?
Someone named Travis, I think, Katie, if I can read it. Thank you. You've been sworn as a witness? Raise your right hand. You just swear to tell the truth or affirm that you will tell the truth in this hearing. Did you observe each person signing it?
And anyone who I did not observe was out of town, and I have an email from them saying that they are against it.
We can only take what you observed. I can't take the other. I can't take the emails or other things unless they do go in front of the notary. So I can't take the petition. You could tell us how many names are on it.
There's 78 names.
Okay, but I can't take, under our rules, we can't take petitions unless the person bringing them has observed each signature. Do you want to take a minute and just mark it, and then you can say, I witnessed all the ones that I've marked with a star or whatever you want to do. Let the record show that the witness has tendered pages 2, what are marked as pages 2, 3, and 4 with signatures, and testified that she observed each of those signatures. And let me get your name on there, too.
Pardon me?
Let me get your name on here, and then we can take it and put it in the record. Yeah.
Is it simply a petition against the project, or what is it?
It says,
Those are people that signed.
petition concerned 1570 Elmwood owners against the proposed building next door at 1571 Maple. That's what it says. And the council will read that. Ma'am, did you want to testify? Yeah, come on up and give us your name.
All right. My name
Clearly.
is Donna Marcus, and my question involves parking. The gentleman actually got me thinking about this. If you are in an area where there is parking for which you require a permit, and this building is in that area where permit parking is required, if people choose not to purchase parking in the city lot, can they get a street parking permit and park on the street with that?
I'll ask one of the staff to answer it, and I think we have someone.
Yes, so when there is residential permit parking restriction on that street, during those hours when that permit is in effect, where the restriction is in effect, only people with those permits can park there. And people that can purchase permits are only those that live on that block where the restriction is. So people outside of the area cannot purchase residential permit parking.
Are the restrictions block to block? Or
They vary.
Would it be in a larger area? So
They
could
can
this
vary.
area be part of that?
Well, this area is in the downtown area, so they would never be eligible to be
Okay, that's
part of
my
a residential permit parking.
Is there anyone else that has comments? Now, we could go two ways, and I'll ask the commission and the petitioner what they want to do. We could continue it to take further testimony, or we can try to have all the testimony tonight. That's the question, and you have something to tell us.
You said we were going to ask the petitioner, so.
You're the attorney, and so you
we
can
do have
tell us your
a
preference.
few questions for rebuttal witnesses. I don't imagine it's going to take that long, so my assumption would be is if you agreed to go forward tonight, we'd call our, they're the same witnesses that have been before, they're not new witnesses. It would be a few questions, I just want to clear up a couple of things, and then I assume that both us and the objector would do our closings, or what is the?
You have some old witnesses. Let me ask the board, are you ready to go further later? They look well rested.
I know, Mr. Chairman, I think we can go a little bit longer if, however, we're not going to reach the point of our discussion tonight. I would suggest that maybe we leave the closings until the next session so that we hear those fresh and then we begin.
Other
Do everything else.
Good idea.
But the closing statements. Thank you, Stuart.
Good idea.
So the record should show all but one of the commissioners is nodding yes, nobody is nodding no, and then we can take the testimony and see where we are at the end.
Thank you.
That would certainly, after each witness, cross-examination would be appropriate if you have something to ask.
Thank you. So are we at that point to call our witnesses?
You may proceed.
I'd first like to call Mr. Michael Morose. Microphone. Could I have this?
Yes.
Mike, so the record is clear. Please state your name.
Michael Morose.
And you testified before in this matter at the first hearing and also in cross-examination today?
Correct.
And you were still sworn in on this matter?
Correct.
Michael, first of all, Mr. Satter strongly criticized your report, something about a market study that was naked or not. He didn't know where you got it. Was, in fact, your report based on a market study that was submitted to the Planning Commission as part of our material and prepared by, I believe it was Appraisal Research?
Yes, appraisal research counselors prepared a detailed market study, and it was cited in my report.
So any of your report that dealt with market was in fact based on an expert's appraisal, or excuse me, market report that both the Plan Commission and in fact any of the objectors would have had occasion to review?
Correct.
Second of all, please define matched pair for me.
Matched pair basically is taking at least two properties that have some similarity except for singular differences and making that comparison. And you can have multiple matched pairs, or as I did in my report, I actually had 3 condos in the same building, so really based on that multiple, there were 3 matched pair analysis done.
So you would agree with Mr. Satter that sort of the trick, or not the trick, but the magic of an appraisal witness is to define what is a matched pair.
Correct.
Tell me why you believe your matched pairs should count.
Because they're in a similar downtown building on having similar units with different viewpoints reflecting similar situations to what could happen if the proposed project is developed.
Are there issues that you found with Mr. Satter's matched pairs?
Yes.
What?
Briefly, with the Wolf Point, which I am familiar with, which is basically a dramatic view down the Chicago River, also to the northwest of River North and Streeterville, River East, etc., and then southeast of the Chicago Loop. It's a dramatic and fantastic viewpoint. It's really not comparable to the subject situation, which has good views, but not to that level.
So whatever, you're not saying that there isn't effect on sales prices at River Bend. If I'm paraphrasing, it just doesn't relate to the situation that we're before this board today.
It's an apples and oranges comparison. Clearly, there's an impact by view, which I don't dispute, but it really isn't appropriate comparison. And then the other probably simple analysis is looking at the comparables provided at 1571 Maple and using a 6th floor unit compared to a 20th floor unit. And if we look at his adjustment, it's about $6,600 per floor. And when you get that big adjustment as far as the floor level, that unit price isn't necessarily unrealistic. And I think we heard a similar comment from a broker here earlier tonight. And again, a second comp is a 6th floor compared to a 14th. Again, a dramatic floor difference. The third is the 8th floor to the 16th. So if they were 1 floor, 2 floor apart, it might be different, but when we're talking a difference as much as 14 floors, it's really, again, a very difficult comparison to quantify.
Mr. Morose, were you able to research the actual original sales prices of units in Winthrop Club/1 Evanston? And based on your research, was there something interesting between units on the north side and the south side of the building?
Well, there were several things interesting. First of all, and it probably has to do with market conditions, the original price points were almost 30% higher than the actual unit sale transactions. And virtually in all instances, what we found with comparable units is the south side units had overall higher price points, and they had higher price points per square foot than the north side units.
One last thing, because there's been a lot of discussion on parking, and someone else is going to make, this plan commission is going to decide whether our assumptions, and our assumptions are correct or not. But in terms of value, in terms of real estate values, not just for Winthrop Club, but for the surrounding area. I mean, if you were asked to value a unit, would in a high density urban site, such as this one, would the availability of on-site parking, or excuse me, of street parking even come into play in your opinion in terms of value?
Practically not, because the public body owns the right-of-way. They control the parking. They can add permit parking. They can eliminate parking. So it's really something that, in my opinion, is not correct to consider that as part of value. If there's a free municipal lot that's a guarantee into perpetuity, that's a different situation. But street parking that can be regulated, no.
So specifically as to Winthrop Club, it's our knowledge that they have at least one-to-one parking or above for their units. Would whether or not we had 100 parking spaces on our site or not on our site affect the value of their units, in your opinion?
In reviewing the KLOA and the staff reports with the way it's going to be supplemented and supported, no.
I have nothing further. I'm done with this witness.
There may be questions. I see a hand, so go ahead.
Okay, when I say 14 floors for the two items, even if you give it $5,000 a year, which would have been completely generous, but that's probably standard, it still doesn't make up $114,000 difference. And I was really just trying to say,
Steve.
faint here, one of something I've never, ever shown property in 30 years to anybody that you did not matter.
Tell us your name. Might as well come up to a microphone and tell us your name. And the gist of your testimony is
Debbie
that
Magnuson,
in your experience as a
and
realtor,
they were
the
saying
view matters.
that I cited a 14-floor difference, which I did.
You did.
In 6 months, even if you adjust per floor for $5,000, which is a lot, that doesn't make up the $114,000 difference in the sale price within a 6-month period. And my point was view always matters. And I don't care if it's a single-family house or a condo or what. It's light coming in, it's everything. And that's it.
You did it already.
Okay.
And any other questions?
So there's no, I didn't say that view didn't matter, if that's her question. So matters.
Any other questions of this witness? Thank you.
We have one other rebuttal witness, and that would be Mr. Stephen Lennett. Steve?
Mr. Lennett has been previously sworn and
Thank you.
testified.
Steve, a few things. In 6-3-6-3, and I believe I quoted that correctly, unlike the chart that's up there, there's an additional line that says, but not limited to. Is that correct?
That's correct. The list in the ordinance or in the plan is not meant to be, and it's clearly not to be all-inclusive. There are other benefits that can be considered.
And you don't have to, would it be your opinion that you don't just check off a box and say, yep, I've done this, or no, I've done this, but it's the cumulative benefits of a project, maybe not even in list form, that really say whether or not this is appropriate for a planned unit development at this location?
I mean, the idea here is that nobody's going to meet all of the benefits, so it becomes a matter of the weight of those benefits, and that is going to vary from site to site, and that's appropriate, and that's why you consider those on a case-by-case basis as a planned development and a special use.
Steve, you've seen the list that was included in staff's report to the Plan Commission. Do you agree, in your opinion, are those public benefits? And if so, are there also other benefits to this project that maybe you should go through again?
Well, I agree with the staff's benefits. They cite 12 different benefits. In addition to that, as the Plan Commission referenced earlier, it's my opinion, based on about 47 years of experience in urban development, that the development of vacant property is a significant benefit. That vacant properties, especially in a very high visible area, in an area that has experienced significant development, tends to reflect poorly on the developmental potential of a property. Also, those properties tend to not be maintained at the same level as developed properties, and they also don't provide the same tax benefits as other properties. There's also significant benefit here to other taxing bodies beyond the city of Evanston. School District 65 will see a significant benefit from the real estate tax. Approximately 65 to 70% of the Evanston tax bill, property tax bill, goes to the school districts. This type of development will develop or engender almost no children. So the benefits to the local school district will be significant. So those are additional benefits that weren't mentioned in the staff report, but that can be considered in the analysis of this proposal.
In terms of in the downtown plan, which we've been not arguing, but presenting our sides as to whether it counts or not, or how it counts, not whether it counts. It does count. Please don't get me wrong. It does count. In terms of working with the intention of the plan, our site is developed or proposed to keep a 4-story building along Davis. That is in context.
Yeah, this is a mixed-use development. It's consistent from that standpoint. Bearing in mind that one is that at this point the downtown plan is 5 to 6 years old. There are significant differences in what has happened in the general economy from the time that was developed. The other is that, in my professional opinion, this is one of the problems with form-based codes. Is that it takes it a step too far, frankly, in terms of how a specific property can be developed. It doesn't work with the developer. It doesn't change from time to time. And I believe that is the reason that the form-based code as a addendum to the zoning ordinance wasn't adopted. I think that's appropriate. That in fact, right now, the plan development provisions and special use provisions of the zoning ordinance are still what controls development here, and I think that, frankly, is appropriate.
I have nothing further. Mr. Leonard?
Don't go away. Someone might have a question.
I do.
Attorney for
Just a quick question. Would you agree that a public benefit is contemplated under the zoning ordinance and upon which the applicants are relying is not something that is simply required by the zoning ordinance? In other words, doing something the zoning ordinance requires is not a public benefit as required in order to be approved for a planned development.
I'm not sure I understand the question, Tom.
We agree that the zoning ordinance requires at least LEED silver certification, correct?
That is one of the benefits that is enumerated as one of potential benefits.
Well, my question is, isn't that in fact required by the code?
No.
LEED silver is not required by the code in your understanding.
My reading of the code is that there is a list of potential benefits. It doesn't necessarily mean that every one of those benefits is going to be engendered by every project in the downtown.
I do understand that. I'm going to a more fundamental question, which is what is a public benefit? So let me make this a hypothetical. If being at least LEED silver is required under the zoning ordinance and the building is LEED silver, is that a public benefit that qualifies to be discussed as part of a planned development?
I think that when you develop a property and it is a silver LEEDs, that is a benefit. The fact that it may be required doesn't minimize the fact that there is a benefit to the community from having that level of development. So the fact that the ordinance wants to have benefits doesn't mean that it's not a benefit. It is a benefit.
So you would disagree with Mr. Krakauer's testimony, which is a public benefit is contemplated under the zoning ordinance in order to, as part of the consideration of getting the allowances that the applicant is asking for. A public benefit is not something above and beyond that. In other words, something that is traded for an allowance. You think it's just whatever's required?
No, you're first of all, I don't think it comes as a shock as anybody that I don't agree with Mr. Krakauer. Second is that you are misstating or mischaracterizing my testimony. The fact is that if you provide a well-designed building, if you do a LEEDs building, if you provide public parking, if you provide a place for recharging of automobiles, you provide landscaping. All of those things are benefits. They benefit the community. The fact that they are enumerated doesn't minimize the fact that they are a benefit. They are. They work to and inure to the benefit of the community.
Well, I would agree that
speaks to your ordinance, the fact that you have that in there, but it doesn't minimize the fact that they're benefits.
I think the commission understands.
I got it. Yeah, I got it. I have no further questions.
And does the petitioner have any? Could you come to the podium so we catch it on film? Then we have a record. Tell us your name.
My name is Lorena Espinosa, and I live in the building 1570 Elmwood.
Have you been sworn as a witness?
No.
Let's do it. Will you affirm or swear to tell the truth in this hearing?
Yes.
Thank you. Go forward.
So he was mentioning about the benefit of the taxes for having a new building.
So you're go ahead.
So our building will lose value. So can he explain the city will gain more taxes from one building and they reduce the income from the taxes from our building? So are you considering? So what is going to be the benefit for the city, the net benefit?
I understand. I understand the question. First of all, I think anybody who's, including me, who's lived in Evanston would be shocked if their taxes went down. But beyond that, it presumes that there is such a substantial impact on property values overall that it is going to impact the overall fair market value and assessed fair market value, and I just don't believe that to be true. Over time, all of these buildings will rise, as all properties do in Evanston, because of Evanston's uniqueness. There are people who live in Evanston only want to live in Evanston. That's always been the case, and it will continue to be the case. It is a unique community within the metropolitan area, and property values just are not impacted.
You're not an expert in property taxes.
Actually, I have been recognized over the years. The late Mr. Murray used to put me on as an expert. I did the tax impact studies, probably 30 or 40 of them, including the tax impact study for Winthrop Place. So I have done tax impact studies over the last 25 years, specifically in the city of Evanston.
So based on your experience, you think there'll be additional taxes?
I am absolutely convinced that there will be additional tax benefits.
But you haven't
I have not done a specific study in this case. That's correct.
Any other questions for this witness? Go ahead.
If the building was shorter and it had less units, there would certainly be additional tax.
So we have a question. If you could identify.
If the building was shorter and had less units and provided parking, it would still have additional tax benefit to Evanston, wouldn't it?
Yeah, development of this property is going, in that hypothetical, of course there would be. It wouldn't be as great, but there would be a benefit.
Could you identify yourself and use the microphone and ask your question?
I'll just come up here. Sure. Candidly, a lot of what you said I agreed with, but the one thing, this is a rental building, correct?
Yeah.
So this whole notion about the uniqueness of Evanston, by definition, rentals are transient. So doesn't that diminish what you're saying? By definition, rentals are people that come and go. So some of the benefits you're talking about, they might be there, but this impact that you're talking about, if these were condominiums, I'd be sitting here buying that a lot more than what you're saying. So what, again, and I'm not an expert, I haven't done the study, but again, I'm putting on my common sense hat. Rentals are not permanent people that want to live here forever.
So
Tell me where I'm wrong.
Tell us your name again, just
I'm
for the
David
record.
Quo.
So we have an assertion from Mr. Quo that rentals will not have this effect. Mr. Ford has a question. And Steve, Steve, you have a chance to respond.
I don't characterize residents that way, first of all. Second of all, from just a purely zoning standpoint, the ordinance is not allowed to discriminate, as I understand it. It's the use is multifamily. How the developer chooses to market that property is beyond the reach of zoning.
Mr. Ford? It is true we can't require only tall people, much as we'd like to.
I think I learned that from you.
Could be. The record should know. Mr. Lennon was a witness in some cases I presented. How long ago was that? We all had hair then.
That's really a lot. It's over 30 years ago. We started working together.
About 30 years, and
you were at the state's attorney's office at the time.
We have not done trials, and there's no relationship other than I remember him as a witness. I remember Mr. Krakow as a witness too, and I guess if we went back to 30 years, then. I would be disqualified, but I don't think there's any conflict of interest now. Yeah.
I figured out how to frame the question. Can someone adduce any evidence to either support or deny the proposition, Mr. Guo's proposition, that renters are transient? I suppose we might want to start with, what do we mean by transient? Is, for instance, someone who comes to Evanston to take 4 years to earn a PhD transient?
You know, I think that in a lot of cases you have renters who are students and people who begin and then over time become permanent residents. I think that's frankly, one of the beauties of Evanston. I mean, I think that, you know, and going back to the 70s when I lived in Evanston, the city council actually made it more difficult to convert rentals to condominiums. There was a condominium ordinance passed. So there's always been a balance in the city of Evanston between rentals and ownership. And I think that that's part of, you know, the attractiveness of the city of Evanston.
Any other questions of Mr. Lennon?
Would you mind if I just made a statement towards that question as well?
Please identify yourself.
Michael
You've been
McLean.
previously sworn.
I'm with the developer. I have been sworn in. So the question of defining a rental tenant as transient, especially in the city of Evanston, but across most smaller cities in the country, as well as larger cities, is becoming much harder to do. And in fact, within a mile of the site, over 8,000 rentals, 56% of the households are rental within a mile of this existing site. So to define all of downtown Evanston as transient would be difficult I think, for any of us who are residents of Evanston to do. One of the other things that is more recent, and again, people who are not in this field, who do not have master's degrees and other degrees, which do qualify them as experts, And just for the record, I do have a bachelor's in sociology from Princeton with urban studies, as well as a master's in science of real estate development from New York University Schack Institute of Real Estate. The new generations and the new companies, as well as the stalwart employers in all of Illinois, Kraft, Hillshire, McDonald's, have all moved over 5,000 jobs to downtown Chicago. And when the newspapers ask every one of them why they moved 5,000 jobs to downtown Chicago, every one of them said it's because that's where the talent is. The talent refers to 25 to 35-year-old, well-educated, tech-oriented employees who the biggest companies in the world have just uprooted 50 years of legacy in the suburbs to come chase. Evanston this year, while that was going on without a single subsidy in downtown Chicago, gave a multi-million-dollar TIF to subsidize an office development as part of a mixed-use project on Chicago and Maine. So we, I think, should ask ourselves, does employment counteract and does lifestyle preferences counteract what might be arbitrarily labeled as transitory as a permanent investment, not just in our residential base, but actually our inability to retain tech companies in Evanston historically. So,
Thank you.
We'll take.
So I agree with a lot of what you said. Here would be my question, though. If you're a sharp young guy from 25 to 35,
Could you take a microphone and identify
again, this is all
yourself?
speculative. For the record, I'm not a real estate expert. I don't play one on TV. So, but I'm looking at these 800 square foot apartments. Some sharp person in Chicago that's driven is going to be looking for a lot more than that. Again, I'm wearing my common sense hat. Common sense. Again, it's speculative. I'm not saying I'm right or you're wrong. I'm just wearing my common sense hat. 800 square feet, $3,400 a month. They're going to be downtown chasing young hotties and all the other things. No, I'm dead serious. They're not going to be in Evanston. I'm dead serious about that.
We believe Evanston can continue to attract the talent that is driving the economic explosion of major cities and minor cities around the country, including Atlanta and Pittsburgh and Cincinnati and Portland and Seattle. We can, if we can provide the housing. Our housing is 95% occupied for that segment of the population, and there is very little growth.
Let me follow that
So
up.
the attractiveness of that unit is well documented, that size unit and that lifestyle is well documented through a number of both public, private, and not-for-profit organizations across the country that studied parking counts, that studied site preferences and space preferences, and overwhelmingly the Generation Y, the future of our corporate growth in Illinois, prefers a small unit with very limited parking next to transit-oriented developments in urban downtowns, including Evanston, who produces some of the top business minds in the country who do not stay here because they do not have the living options that they require as sophisticated young employees of some of our major companies.
Then why aren't, okay, I mean, yeah, again, the common sense again, well.
I think.
Are we getting a little far afield here?
Yeah, we're getting far afield, and we've heard the argument.
And we're not giving closing arguments tonight either. So
Clearly, the sources of funds for this are think it's going to be successful, and some people in this room don't. So, yeah, come forward, testify, or ask questions.
Mr. Ford, I think the question you asked which started this whole thing, was a very good question. And as part of Michael's answer, which I don't know if it's true or not, but I assume that it is, that 56% of the people who live in the downtown Evanston area are rentals. That begs the question, which is maybe a corollary to your question, which is that a good thing? Do we want downtown Evanston to be all rentals or predominantly rentals, or is it important to keep a balance? Is that important to the city?
Under our ordinances and Constitution, there are some real problems in regulating that.
I'm not a mathematician. We're all not experts in something, and mine is in mathematics. Do I understand that 44% of the people who live within a mile of downtown live in owner-occupied housing? That feels to me 44-56. You could move that balance a couple of percent, but it feels kind of balanced to me.
Any other testimony? Let me ask the board, how do you want to proceed? Should we, we've taken the testimony and closing arguments, we could do at the next hearing. There may be some questions for staff, excuse me, that we could get. How do you want to proceed? They're frowning.
Well, if
Your suggestion.
if there are not additional questions for staff, Mr. Chairman, then I won't move yet, but I would suggest that we continue this hearing to Wednesday, the 14th of January, which will be the next regularly scheduled meeting of the commission.
Commissioners, is that satisfactory? So there's, is that a motion?
It is now, as long as it's been seconded.
There is a motion, and it's been seconded, to continue this hearing for closing arguments and deliberation only, and with accept an amendment and close testimony now.
Yes.
And the seconder agrees? So we have a motion to close testimony, and the remaining part of the case will be continued for closing arguments and deliberation to the next regularly scheduled meeting, which is January 14th. Is that, all those in favor?
Aye.
And opposed? I'll let the record show that everyone was in favor. We are obligated to take public comment at the end of our meetings. More generally, if someone wants to say something, we'll hear it. But we've closed the testimony on this case.
Two things, Mr. Chairman, totally as a public comment. One, I would like to apologize to the board for my outburst before. It was unprofessional, and as you see, I backed off tremendously after I realized that. Second of all, thank you for your time and consideration on this, what is a very difficult matter here today. Thank you.
I echo his second comment. Point of order. Do you have a suggested guideline for time limits on closings?
Usually it's about 10-minute limit.
I'm not trying to hold anybody to it. I'm just trying to figure out what we need to work in
That's usually
generally.
what we do. Commissioners, we have another matter on the agenda, which is to set the times for the meetings next week. In your packet, you got a calendar which provides for meetings on the same schedule we have now.
Move approval of the schedule as the staff presented it.
Is there a second? A discussion? There's no discussion. All those in favor?
Aye.
Let the record show that all of the members present voted in the affirmative.
Any more?
Is there a motion to adjourn? There is a motion seconded, and all those in favor? That too is unanimously adopted. These are wonderful times. So we're adjourned, but the hearing is not over. It is continued to a date certain. I want to thank the witnesses and people who spoke. Nobody was redundant. Very nice.